So I'd like to call to order the special meeting of the Fairfax
Recording
Town
in
Council.
progress.
Fairfax Town Council. It's Thursday, February 29th, 2024. It's 6:30 p.m. and we're in the Fairfax Women's Club, 46 Park Road, Fairfax, California. And with that, I'd like to ask people to join me with the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Madam Clerk. Can we do a roll call vote?
Yes, Mayor. Councilmember Ackerman.
I'm here.
Councilmember Hellman.
I'm here.
Councilmember Catrano.
Present.
Vice Mayor Blash.
Here.
And Mayor Kohler.
I'm here.
All present.
Thank you. Could I get a motion to approve the agenda?
So moved.
Second.
Okay, so that was Councilmember Cutrano, second Vice Mayor Blash. Roll call vote.
Councilmember Ackerman.
Yes.
Councilmember Hellman.
Yes.
Councilmember Catrano.
Yes.
Vice Mayor Blash.
Yes.
Mayor Kohler.
Yes.
All ayes.
Okay, and I'll go ahead and read the land acknowledgement. The Fairfax Town Council acknowledges that we are located on the unceded ancestral lands of the Coast Miwok people of present-day Marin County. We honor with gratitude the land itself and all of its ancestors, past, present, and emerging. Now I'll go ahead and read the meeting protocol. The mayor shall maintain order at the meetings. The council and the audience are expected to refrain from using profane language and or ridiculing the character or motives of council members, staff, or members of the public, and to maintain the standards of tolerance and civility. Please turn off all cellular phones or place them in the silent mode. The town council will review the agenda at 10 o'clock p.m. to ascertain which items, if any, will be continued to another meeting. Any matter not started by 11:30 p.m. will be continued to an adjourned or regular council meeting unless the council votes to suspend this rule. And before we do our first item, I just want to make a statement. Some of you participated in our last meeting and there were a number of offensive comments that came out. And I want to make the public aware that our ability to silence offensive comments is constrained by the Brown Act and the First Amendment. The Brown Act requires this body to take public comment on agenda items and to allow open time for public expression at each regular meeting. The law permits us to mute a meeting attendee if their speech is disruptive and prevents this body from accomplishing its business in a reasonably efficient manner. Fairfax Town Council meetings are a place of business, and the council has work to do. For that reason, these types of public meetings are a limited public forum where we can enforce reasonable restrictions on comments. As provided in the Brown Act, comments on non-agenda items, which we won't have tonight, must address matters within the subject matter jurisdiction of the Fairfax Town Council, and comments on agenda items must relate to the item. Accordingly, if a comment falls outside of these categories, the council is authorized to move on to the next comment. So with that, we'll move on to our first item, which is a public hearing. And did our attorney want to make a couple of statements?
Yes, I'll start us off. Thank you. First of all, tonight, I am representing staff. And the council has legal counsel with Kylie Otto. She's on Zoom up here. You've seen her before, I believe. And so this is a directed referral from a planning commission item. And Linda will do the staff report, but I just wanted to give a few procedural notes. We had this originally scheduled for February 7th. There was a problem with noticing. And so we continued it to today, February 29th. But it is a de novo hearing on a planning commission matter. It's a revocation hearing for the permits and entitlements at 79 Wood for a single family home. And I think with that, I will turn it over to Linda for a staff report.
Before Ms. Nail mentions that, I want to mention that we received a number of documents on 3 separate emails from Mr. Friedman's attorney, and I have looked through all those items. They looked very similar to the items that were sent before the February 7th meeting.
Right.
So with that, Ms. Neal, would you go ahead?
Yes. In January of 2022,
Linda, you got to speak closer to the
Okay.
mic, please.
hang on, let me readjust
I'm-
here. Is
I'm-
that better?
Yeah, that's better.
Okay. In January of 2022, the Planning Commission approved a 2-story single-family residence and a detached combination 2-car garage and accessory dwelling unit at 79 Wood Lane. The commission approved the project based on the October 7th, 2021 architectural plan set prepared by Laura Kierline of Frederick C. Devine Associates architectural firm after holding a second public hearing on the matter to review the required plan changes that resulted from public comments and commissioner comments at an earlier public hearing. The building permit for the project was issued after the town reviewed the building plans and determined that they were consistent with the plans approved by the Planning Commission. Shortly after the building permit issuance, the building official stopped the construction when he determined that the area underneath the house that was approved to be a combination basement for mechanical equipment and a crawl space had been excavated into a full basement out of compliance with the approved planning set and the building permit plan set. The applicant and his attorney filed an ex parte application in Marin County Superior Court in August of 2022, seeking to lift the stop work order. Through negotiations, the property owner agreed to work with the building official to reach agreement regarding the basement. The applicant subsequently modified the subfloor so that the sides of the area that were supposed to be crawl space had slightly higher finished elevations than the mechanical room at the center of the building footprint. On June 5th of 2023, the following year, the building official visited the site to perform a framing inspection and discovered that the footprint of the house and the floor plans had been altered without the required town approvals, and changes included relocating the detached accessory dwelling unit that was approved as part of the detached garage into the now re-excavated rear portion of the basement of the main house, and the rear deck of the second floor of the house was converted into living space for a second floor junior accessory dwelling unit. The building official stopped the job again because the structure was not being built in compliance with the approved planning plans or the approved building permit plans, and the garage wasn't being built per the approved plans. At that point, due to new state regulations that do not allow discretionary review of accessory dwelling units or junior accessory dwelling units, and after discussions with the applicant, his attorney, the town attorney, and staff, the stop work order was lifted after the applicant and the town agreed that work could continue on the ADU, the portions of the JADU that did not change the Planning Commission approved exterior of the building, and the portions of the house that had been approved by the Planning Commission and remained unchanged. The applicant was directed to submit a planning application, amending the plans and providing an updated geotechnical and engineering reports and required fees to modify the approved Hill Area Residential Development Permit, the excavation permit, the design review permit, and to obtain and modify other discretionary permits that might be altered or required by the proposed changes that he was making. On August 10th of 2023, the building official visited the site after hearing from a neighbor who was concerned about excavation occurring on the site in the area of the proposed garage. While there, he observed that the applicant had commenced work on items that he had agreed to obtain Planning Commission approval of before proceeding with their construction. The building official stopped work on the job again. The applicant, through his attorney, again filed a writ asking the court to have the town allow him to begin working again. On September 5th, 2023, the judge denied the writ, set a future court date, and directed the parties to work out the issues. On September 6th, 2023, the applicant filed an appeal to have the town council direct staff to allow him to continue working. The town council subsequently denied that appeal. The applicant has never submitted the required planning application to amend the planning approvals. So on January 11th of 2024, the Planning Commission held a noticed public hearing to discuss the project and to consider whether to revoke the planning permit for the project or to temporarily suspend the approval to give the applicant adequate time to prepare the required plans, amendments to the engineering report, revised excavation and drainage plans, and to submit these with the required fees to amend his original project approval. The commission took action to temporarily suspend the planning approval. Tonight's meeting is for the town council to consider a directed referral to revoke the planning approval due to the applicant's failure to build per the approved plans and to comply with the conditions of the project approval. Site inspections and a review of incomplete modified plans that the applicant submitted to the building department have revealed that the following changes to the footprint and the exterior of the house that are not reflected in the approved planning or building department plans, in addition to the changes described above, were observed by the building official in the field. The entire house structure has shifted approximately 3 feet toward the western side property line, and a window well for the basement ADU was built 5 feet from the eastern side property line. The front porch that ran the width of the house in the approved set was removed and has been replaced with a small enclosed entry area in the center of the front of the house. The two-car garage has been replaced by the two-car garage that was supposed to be a two-car garage with an attached ADU has been replaced by a 14-foot wide one-car garage, and the ADU has been moved into the basement. The sloped slate roof over approximately the front third of the house has been replaced with a second-story roof deck. New windows have been added on the east and west sides of the structures, some to get light into the basement ADU. A window on the back of the house has been replaced with a sliding glass door to a rear ground level deck. The staff has been unable to perform a complete review of the changes that have been made to the structure from the plans that were approved by the Planning Commission because to date, no planning application with the required complete set of plans and the updated engineering reports and grading and drainage plans have been submitted. Relocation and redesign of the exterior of the house and garage ADU structure and enlargement of the basement beneath the house without revised grading and drainage analysis and plans to verify that the changes will not alter drainage patterns and will not negatively impact the public road or neighboring properties is not advisable. All of the hillsides behind the houses on Wood Lane are identified as landslide hazard zones based on the landslide hazard maps that were prepared after extensive investigation and site surveys done by the California Division of Mines in conjunction with Marin County towns and the cities of San Rafael, San Anselmo, and Ross in 1976, and they were updated in 2013, and they coincide with the town's 2010-2030 general plan safety element landslide hazard map. And they show the whole area on the upslopes on either side of Wood Lane are in landslide hazard zones. Prior to any development, the Wood Lane area was a valley with steeply sloping sides from which silt has washed down the hillsides to the valley floor for many years, blanketing the site with varying thicknesses of relatively weak and compressible fills and soils, which are subject to differential sediment due to foundation loading and creating the flat house sites where the homes are now built. The hillsides above the houses have stability issues that can become obvious when Marin gets a lot of rain falling over short periods of time. Historically, there have been 2 slides in the Wood Lane area that have destroyed a duplex and a house beyond repair. There's a third site with a slide above it where the only reason we were able to make it safe is the applicants came in to do a 50% remodel, and the engineers, the project engineer and the town engineer wanted a debris barrier, an expensive debris barrier to be built because there was a moving section of soil above the property, right? And the applicants argued that it was too expensive. We finally got them to agree to make the back wall of the house the debris barrier, and they couldn't put any kind of bedrooms up against that wall because that was going to stop the soil if the hill decided to come down, right? So these types of features on sites in landslide hazard zones is why the town adopted the Hill Area Residential Development Permit Overlay Zone permit process. It was adopted to provide equal protection for project sites, neighboring residential sites, and adjacent public improvements when new construction is proposed. The project construction is in violation of the conditions set forth in the Planning Commission Resolution 2022-01. This hearing is being held and conducted as provided in the town code, which permits the town council to assume jurisdiction on matters where action has been taken and is normally finer at a lesser level of authority, and giving the council the authority to conduct a de novo hearing on the application. All alternatives that were available to the Planning Commission are also available to the town council. The recommendation is that council adopt a resolution of the Fairfax Town Council revoking and rescinding Planning Commission Resolution 2022-01 for application 21-17, including approvals for a Hill Area Residential Development Permit, Design Review Permit, Excavation Permit, and Tree Removal Permit, and a minimum and combined side yard setback and retaining wall height variances and accompanying building permits for a residence located at 79 Wood Lane. And I did have one correction to the amended resolution.
So I just want to point out
in
that
this-
there's a supplement
Yeah, that's the
to
one.
this item, and it's the supplemental amended resolution.
Correct. That's correct. Thank you.
And you have a new correction?
Yeah, just on page 7, under the last now therefore be it resolved number 4.
You need to speak
Oh,
closer to the
sorry.
mic.
On page 7, after the now therefore be it
Oh,
resolved.
that's not on page 7. Oh, wait a minute.
On 7 in mine.
Okay,
Okay.
sorry, looking at the
That's
wrong
okay.
page.
Number 4,
Okay,
that starts with excavation permit moreover. Excavation permit moreover should be deleted. It should just start with the shifting of the structures has resulted in a further encroachment into the required setbacks. And then it goes on from there. That's a cut and paste error. We don't know how that got in there.
okay, so excavation permit moreover is deleted and it starts the shifting of the structures, et
Yeah,
cetera.
with a capital T for the,
Okay,
okay.
thank you
And that
for
would
pointing
conclude
that
my
out.
report.
Okay, are there any questions of staff at this time by the council?
So
Councilmember
just,
Cutrano?
sorry,
Go ahead, Councilmember.
just simple clarification that were council to pass this resolution tonight, the next action for the applicant would be to complete their second application and come back to the planning commission with the appropriate studies, including.
So nodding your head is not right?
They would resubmit. They would have to
Okay.
resubmit for the changes that they
Yeah,
want to make.
yeah.
Yes.
Okay,
Okay.
just because we're recording. Okay, Councilmember Cutrano?
Yes, thank you, Madam Mayor. Thanks for the staff report. It was super extensive, exhaustive. Quick question on the different permits that are being removed. I know in the court ruling, the judge was saying, you can go forward with certain things that had already been approved, but you can't go forward with all the other things that no plans exist for. And is that I understand the concerns about not knowing hazards related to drainage, geotech, et cetera, but tree removal, that sort of stuff. Is that just because the plan is kind of a moving target and we don't know where things are ending up, or?
You need to-
That's correct.
Okay.
We never got, he gave a partial submittal of plans to the building department, but they don't even include elevations and they don't have finished floor elevations. They don't have a lot of information. They don't have a soil, they don't have a grading and revised grading and drainage plan. There's no revised, we don't have complete plans to do a review of what he's building,
Okay.
right? We don't
Yep.
know the impacts of it.
Yep. Thank you. And then questions, there will be a time for questions for the
applicant.
applicant. Great.
Yeah.
Okay. Thank you.
Just want to clarify. So the plans that Mr. Friedman submitted were not signed by a licensed architect and they were basically plans that he may have drawn up, but they were only partial and they were not signed by a licensed architect. Is that correct?
That's correct.
Okay. So I want to ask, okay.
They didn't even have scales on them.
Okay.
They didn't,
But the bottom line is they were more hand-drawn sort of things. Councilmember Catrona?
Sorry, one more question for staff. I noted, the resolution has all the things that could not be done or that would be revoked associated with the project. However, the revised reports and plans would be due March 5th, that there's something in there about that. Then the other thing was the property can be immediately weatherized. And I was looking at attachment H or some of the things that the neighbors on that street were concerned about, and looking at the basement filling up with water and concerns about that pooling over and stuff like that. I'm curious why is it that they can weatherize the project site, but they're not required to, cover soil or do certain things that might affect neighboring, properties?
So that was a condition that the Planning Commission requested when they took action. And the March 5th date was one that the Planning Commission had requested that he have everything submitted back by, and it is clear to us that that is not Mr. Friedman's plan, and he wanted to appeal his temporary suspension of work. And instead, the council has a directed referral here before them. And so this is a de novo hearing. It's as if we're doing a revocation hearing, brand new, taking evidence. So we're not looking at anything that the Planning Commission has or has not done or has required, including the weatherization, but that was not completed on the site.
And that's perfect. And it sets up the follow-up question, which is in the event that these permits are revoked this evening, I'm sure neighbors are watching or also wondering what happens to that site. And the owner would have to reapply or resubmit plans and whatnot. But in terms of weatherization, or we have a week of rain coming yet again. So I guess I'm just wondering, is there any clarity on what happens in the interim?
We can take a look. We can have building official go out and take a look and see if there's any danger of any, mud into the street, that kind of thing.
Okay, thank you.
Mhm.
That's all.
I just have one follow-up question from that. I mean, typically weatherization is kind of a safety measure for the structure as well as surrounding structures. Could we, and maybe this is a question for Kylie, if we move to revoke tonight, could we still require the weatherization? Because that's sort of a critical piece that hasn't been completed, is my understanding, even though it was agreed to back in December. So would we be able to make some sort of a change to require the weatherization continue?
So the weatherization, as I understand it from the building official, is really for the site. And it's to keep the mud and the soil from coming off the site and going into the street, and trying to put up a straw wattle. And maybe Mark can speak to it.
Yeah, it's a combination of straw wattles and straw over the site and debris barriers. And to date, none of that has been done. And that is required during winter construction.
Okay, so I understand about weatherization, but my question is, it's not just to preserve the existing structure, it's something to prevent more mud flowing from the site
Absolutely.
onto other people's properties. So to me, I think Councilmember Catrano raised some good points about weatherization. And I think that's something, depending on what we do tonight, we really need to have that piece of the work continue, regardless of what we do with the rest.
Yes.
Do you agree with that?
I do agree with that, yes.
Okay, looks like Kylie Otto wanted to say something.
I did. I apologize. Depending on what the council decides to do tonight, you could always direct staff to ensure the safety of both the property and the adjacent neighbors. It doesn't need to be done as part of the council action beyond just directing staff to do their duty. Basically, staff would always have the ability to go out and preserve and ensure safety. So if there's an issue, they can do that in and about without direction from the town council.
Okay, so that would mean if we move forward with the resolution, we wouldn't have to change the resolution. We could just require weatherization as a separate item.
You could just direct staff to ensure that the property is properly weatherized or ensure the
Okay.
safety of the neighbors. If there's concerns for that, you would simply direct staff to ensure that that occurs.
Okay, and also to ask you, since you're our counsel tonight, Kylie, now I think we've asked our questions of staff. Do we have an opportunity to ask questions of Mr. Friedman or his counsel as well at this time, or should I open the public hearing first?
You should open the public hearing, allow the applicant and his attorney, if they both would like to speak. You can always ask questions of them if you would like. That is at the council's discretion.
Okay, so normally during a public hearing with public comments, we don't do interaction. So I'm a little concerned about the process.
Well, normally you don't normally have interaction with the individual speakers. You are correct. In this case, you're talking about a revocation of a permit. So it is proper to take their testimony if you have clarifying questions for them, to be able to ask them questions so that you can get the proper information. In this case, we want to make sure that we're giving the applicant due process. So if you have questions, I would encourage you to ask them either during the public hearing. You can either take their testimony, then take all the other testimony, and then bring them back up for questions, ask them questions at the time, whichever you feel is appropriate. But I would suggest you decide before we start the public hearing what you think would be the best.
Okay, well, I would prefer that we go through the public hearing, close the public hearing, and then ask the applicant and or his attorney questions. So I want to go that way. I think that's more fitting with the way we usually hold these things. So with that,
Well, but you would like to, right now, I think you would like to give the applicant time to present.
right. So, okay. There's too many attorneys in the room. And I think there's one on the screen. I'm going to ask our attorney tonight, Kylie Otto, at least from what you just explained to me, we can give his attorney as well as Mr. Friedman time to make their statements. And then we can take the rest of comments through the public hearing and then bring them back for questions. Does that work?
That does work. I would also suggest that you allow him to have an opportunity to speak at the end of the public comments in case there's additional things he would like to add. That is pretty typical when an applicant is being opposed, to allow them to come back up and basically give you additional information.
Okay, so I would close the public comment, close the public hearing, and then ask them to come back to make any comments they wanted to have.
You would still have it in the public hearing. You would simply
Okay.
applicant speak, public members that wish to speak,
Okay,
applicant can come back up to readdress, and then you could close the public hearing or keep it open and just ask questions. Either way, it's still all part of that process, but you could close it so you officially stop additional public comment. But if you had questions either for staff, for myself, or for the applicant, that would be appropriate to ask at that time.
okay, and I think I beat this one to death. So with that,
No, that was
because this is a duly noticed public hearing, I would like to give people 3 minutes to speak. And a question for Ms. Otto, to beat this a little bit more, does the applicant as well as his attorney each get 3 minutes? Or would they have the luxury of going longer?
I would suggest you give them more time.
Okay.
You can limit it to 3, but I would prefer you gave them additional time to ensure that they have the opportunity to get all of the information so that you can
Okay.
create an informed.
All right, we'll do that. But for the rest of folks during the public hearing, you have 3 minutes to speak. So with that, I'll open the public hearing. And would Mr. Friedman or his attorney like to speak first?
Madam Mayor, this is Aaron Silberman. I'm counsel for Mr. Friedman. I'll be speaking on his behalf for this portion of the meeting. Thank you. May I proceed?
Yes, could you repeat your name? I thought Michael Harris was the attorney. Did I?
Richard Harris is my
Richard
colleague, and he
Okay.
was not available tonight, so I'm stepping in for him.
And could you repeat your name then?
Yes, it's Aaron, Aaron, Silberman, Silb as in Bravo, Erman.
Thank you.
And I'm at the same firm as Mr. Harris.
Okay, thank you very much.
You're welcome, and thank you for the opportunity to present to you. This presentation will be fairly brief, mostly because we submitted a detailed written statement today, which is part of the record, as I understand it, and that states Mr. Friedman's position. So my goal here really is to just highlight a few things, and first and foremost, that I hope the council has had a chance to review that submission and consider it, and will consider it. At a high level, the submission describes concerns about this town council's authority to act as it has on this directed referral, due process concerns about the hearing, and concerns about bias. But as far as the substance is concerned, we heard already, I believe it was, in the staff report from Ms. Neal, a chronology. There were a few items which, we would disagree with, but primarily the sequence of events and the dates were correct. And I would draw your attention to, in particular, to the events starting in June of 2023, because that's when there was an agreement reached. That's there's an attachment, E as in Edward, to the staff report. That's the email about that, about three particular items that Mr. Lockaby, the inspector, and Mr. Friedman discuss, and Mr. Friedman's agreement on how to proceed with those. And that number three is interesting because what you will also see in the record is that after the writ hearing, in which court ordered the town that deprivation of the license without a hearing was illegal. That's what ultimately led to the hearing in January 2024. And shortly before that, 10 new concerns were raised. Now, this is not because there were facts unavailable to the town staff prior to that January hearing, going back to June. We would submit that those 10 new concerns were because the town staff were looking after the fact to justify what the end result that they wanted, which was to require Mr. Friedman to do something that the building code does not require, which is obtain approval for all changes as he committed the construction as opposed to the end of the construction. That was a bigger number of new changes to position of the staff. But the more substantial ones are the ones that were raised. They were mentioned by Ms. Neal a moment ago, and they were raised just days ago about drainage concerns, mudslides, water concerns. Those are all brand new, and there is no reason why those could not have been raised earlier, except the logical conclusion that, again, the staff was looking after the fact to add reasons, add justifications for the actions it had already taken. Going back to June, and Ms. Neal took you through those, the actions after that, the stop work orders after June of 2023. We believe that the council should look at that and consider what that effect that has on the credibility of these allegations. Why would they have been raised at these late dates, right before the January hearing and right before this hearing, if they were legitimate and actual concerns, as opposed to after the fact justifications to try and get a result that the town staff desired. And then the last thing I'll say, and this we mentioned this in our submission, but I think it bears repeating, which is the town council, of course, has primarily, if you boil it down to it, the town council has two responsibilities: one, to comply with the law, and two, within the confines of the law, to do what's in the best interest of the town, and and make its determination on the facts objectively what that is. What the town staff is proposing here is to take a construction that is largely constructed. It's not complete. It's not near complete, but it's been under construction for quite some time, and freeze it as is in an uncompleted state. Continue with litigation, which has been filed over the legal ramifications of that, which again that's in our submission, explaining that. I believe that's addressed in the staff report too. That's what the town staff is proposing. What we are proposing is Mr. Friedman completes the construction. He submits completed plans when he is done. So, any further minor changes, he doesn't have to come running in and getting more changes approved. And then he submits completed plans, and those are approved. Those are submitted for approval. Whether they're approved or not, obviously, is up to the planning commission at that point. But Mr. Friedman understands that he would be risking that he doesn't get approval at that point, that he doesn't get a certificate of occupancy at that point. But the house is done. You don't have these ongoing, you mentioned the weatherization concerns. You don't have ongoing weatherization concerns. You don't have an uncompleted house, an eyesore sitting there. I would submit to you that result is within the law and it is in the best interest of the town. And so the town council should allow that to happen. And so with that, we'll cede the rest of our time. Mr. Friedman is not going to present right now. We will listen to the public comment and we appreciate the opportunity to respond to further questions later if that becomes something that should be done. Thank you.
Thank you, Mr. Silverman. So with that, we'll move on to public comment within the public hearing. If anyone in the audience or on Zoom has comments, come up to the podium. I don't see any. Do we have any on Zoom? Oh, I see someone coming up. Can you set the timer? It's not working.
My internet is running slow, but I have the timer on my computer.
Okay.
I'll try to make it quick, but you can just wave.
Okay. Sounds good, Rick.
I hear what the attorney said. It sounds like having another incomplete project in Fairfax is not in the best interest of anybody. However, this is highly irregular, is to go out and to build something and to finish and then try to ask for an apology. And I would suggest that if this is done, that it be compliant with 2024 codes, not the codes that were in effect at the time that the building permit was first filed or the planning commit was first filed with the planning commission. I was at that meeting. This was a controversial project to the neighbors at the time. And I would also expect that maybe the town could have some type of contractual amendment to that effect, that they are, able to demolish something that is not to code and put a bond up in the amount that town officials determine to be a proper amount to make sure that a blight doesn't exist on Wood Lane. Thank you.
Thank you. Next commenter.
Good evening. Candace from Fairfax. I've met Mr. Friedman a few times. I'm semi-familiar with what's going on. I actually hiked past this construction project today. I find it interesting that we focus on building codes, fines, fees, red tagging, but we're willing to eschew a lot of the traditional Fairfax practices of building, like the size of our buildings and heights of them. All of a sudden that has changed. Where we build, whether it's our ridge lines or in slide areas. I appreciate the council's interest and obviously Mr. Lockaby's interest in all of this and trying to figure out what's the right thing to do, but I'm pretty sure we're short on housing. And someone's trying to build an additional house here in Fairfax. So if housing is our question, I say we get it done. If it's a question of codes and changes and fees and fines and everything else, well, let's get to the bottom of it and wrap it up. 2.5 years of construction is a shortage on housing available in Fairfax. Regarding slide issues or environmental impact reports or anything else, I think we have a lot of questions we could ask about possible future building in Fairfax with that. So in my opinion, I say we give Mr. Friedman the ability to finish his home, charge him what you guys need to charge him for any changes, and get it done and get another house available to be lived in Fairfax. Thank you.
Thank you. Next speaker, please.
Mark Bell, Fairfax. Don't even, I was going to say you could save your energy on the timer. 2 questions. Why didn't he just build what he submitted? That's to me like the most obvious question. And then the second one is, if the house foundation moved and is encroaching next to the neighbor before they pour the foundation, so people go out and check to make sure that the foundation is going to be poured in the correct location? I mean, maybe somebody dropped the ball on that, but those are like 2 of the questions. How come this has gotten to this point so far down the road? Why wasn't this pretty obvious early on if the foundation isn't to what the plan specs were? That's it.
Thank you. Are there any other speakers in the room? Seeing none, are there any speakers on Zoom?
There are several speakers on Zoom. The first one is Michael McIntosh, followed by Renew. Michael, you are unmuted.
Thank you very much, Christine. I'm actually calling in more of a procedural thing. I still have a cough, so I didn't want to interrupt your meeting. But my first question is, why do we have 2 attorneys on this? I think if Janet's been apprised of all this stuff and involved in all this stuff, I'm sure the new attorney is adding benefits to it, but it's still an additional expense to the town. And I would hope that our attorney could certainly oversee something as simple as this. The second thing is really a complaint. So here, the town council is asking people to weigh in on something. And you're providing the speakers with 3 minutes to attack or support this project. But whenever there's something that's controversial that the town is trying to promote, such as your policies or
This is not related to the agenda item. Please stay on the agenda item or I will have to cut you off.
Barbara, that's incorrect. I'm speaking to the item on Wood Lane, and I'm comparing it of why it's tried differently. And it was a procedural question of comparison. I also agree with Candace that that house should be tightened up and finished. If there is an appropriate fine at the end of the day, so be it. But why would you want to blight the town? Why would you want to put the town at further risk? Why would you want to have the builder incur additional expenses as just an additional hardship? It will benefit the town to complete the project and to discuss what is or isn't done correctly. So please consider those comments. Thank you.
Thank you. Next comment.
The next speaker is Renew, followed by Maya. Renew, you are unmuted.
Hello there. My name is Renu Malhotra. I live right next door at number 85 Wood Lane. And I am so ready for the construction to be done, as you might imagine. It's been a long, drawn out process. Some of the changes that Kobe has made along the way, I was very unhappy with, like the humongous basement, but that's not what this is about. On the flip side, I'm actually glad about the changes made with the original 2-car garage at the back with an ADU at the back. That has now become just a single-car garage, and that is less impactful to the hillside, which my two main concerns all along with this property have been about the stability of the hillside and the drainage and how it could also impact me. We have built the adjoining concrete wall between us. Kobe has, with consulting with me. We collaborated on that. It's not complete. And I've spoken with Kobe already about the way the water is currently draining behind his retaining wall at the back that faces the hillside, and the water is draining onto my side and coming around. So we've already discussed that. He's already said he will take care of that. But the winterizing needs to be done. And it is, I also, if there's a way for the legal part of this to be satisfied and allow the construction to be complete, it's so close to completion. From the outside, it must be at least 90% done. And that's my input. Thank you.
Thank you. Next speaker, please.
The next speaker is Maya, followed by Lynn. Maya, you're unmuted.
Hello, thank you. Thank you, council members. I want to just voice my agreement that the unfinished home is an eyesore and it's not benefiting the town or the neighborhood. And that if the construction could have been completed by now, the questions of these environmental hazards would not be happening. I also just had two questions. First, I'm curious why the town council is overturning the planning commission's decision to just suspend the permit and is moving to revoke, and if there was something that had happened in the interim that caused the town to take this additional action. And then related to that, what are the legal costs associated with this endeavor of revoking the permit? When I didn't hear any explanation of reasoning from the town why they would escalate the planning commission's decision to just suspend the permit. And I will yield the rest of my time. Thank you.
Thank you. Next speaker, please.
The next speaker is Lynn, followed by Dee Lee. Lynn, you're unmuted.
Hi. I give it a big fat no. And I think we're kind of in this new order of do what you want and say sorry later. And how much money can I pay you? It's encouraging entitlement to let a project like this go through. I'm really sorry that the neighbors have had to live with this, but who would even think of building a garage without getting structural engineering plans, architectural plans signed, all processed through the county and approved. I mean, it's ridiculous. And if everybody now, I guess, gets one strike to go build whatever we want on our property. I mean, is that the way the town goes? I'm really sorry that the neighbors have to put up with that. It's not fair. I mean, I know everybody's leaning on the town, but I think it's the guy who paid somebody to have a shovel to put the first hole in the ground and say we're building, and we're ignoring everybody else. We can do what we want. It's entitlement. It's wrong. We've got a lot of problems with mudslides around here. It's wrong. I hope he's got a great insurance policy so everybody in the neighborhood can get paid off. It's just so wrong in every way. So I guess we all get one strike. And if that's the way it's going to be, let's make an announcement and say everybody can build whatever they want, whenever they want, wherever they want. That's it. It's infuriating. It's really this entitlement attitude. It's offensive, and it's wrong. So that's it. Sorry the guy made bad decisions. You have to pay back and take it away. Take it down. I'm sorry. That's it.
Thank you, Lynn. Next speaker, please.
The next speaker is Dee Lee, followed by Rick and Heather. Dee Lee, you are unmuted.
Thank you. Thank you, Council, for hearing me. Deborah Benson, Cascade Drive, Fairfax. I kind of pretty much agree with what Lynn just said. I mean, why do we have a planning commission? Why do we have building codes? Why do we put all of the other citizens in this town through making application, submitting plans, following those plans, and give Mr. Friedman the opportunity to not abide by the rules? It's not right. It's not right. And the comments about what this is costing the town, well, this is costing the town because Mr. Friedman decided to take it to litigation instead of following the planning commission's findings to begin with and the building inspector's findings to begin with. And I hope you stand firm on this, because it's only fair to every other person who wants to do some sort of building or remodel in this town. Follow the rules. They're for everybody. So that's all I have to say. Thank you.
Thank you, Deborah. Next speaker, please.
The next speaker is Rick and Heather, followed by Michael. Rick and Heather, you are unmuted. I think you need to unmute yourself.
Oh, can you hear me now?
Yes.
Oh, okay, sorry. My name is Heather, and my husband Rick and I are the next door neighbors to this project on the other side to Renew. So we've been living right next door to this whole process. And I would like to say that we feel that allowing this building to be approved as is wrong, and also is a dangerous precedent to set. Kobe has broken so many rules and done things that disadvantage our property value, as well as put our property at risk. And with seemingly a brazen strategy of ask for forgiveness later, we feel it would really be a disservice to the town's process to allow this to pass through. It makes us ask, as other people have noted, why even have a planning commission? Why even have planning laws if you can just build what you want to build and ask for forgiveness later? It's really been an upsetting part of living in this neighborhood that we feel very positive about. We love Wood Lane, and it's been a really hard and kind of ugly process to go through. And now we have this big monstrous house, and I know that next to us, and I know that we can't do anything about that, but I do feel like he needs to be checked in his strategies because they're wrong. So yeah, I understand that it's an eyesore and that people are ready to have it move on and be approved, but we're just really upset by so many of Kobe's actions, and his disregard for our home, our family, as well as our neighborhood. Thank you.
Thank you.
The next speaker is Michael. Michael, you are unmuted.
Hi, thank you, council members. I just would like to point out, I've examined the town code that speaks to how revisions to construction projects are supposed to be addressed. And as someone who works in the building trade, this is pertinent information for myself as well. And this whole situation could have been avoided if the town code was clear on when a change to the plans triggers a revised drawing. It's completely ambiguous. There's no timeline given. There's no metric for what constitutes a change that would require revised drawings. And so the sort of lacking language in the code created by the town has caused this whole issue. So I would urge the town to examine that code and create an actual tangible process for how changes to construction projects would require changes to the drawings and further review by the planning commission. Everybody knows that you have a plan, but when you put that plan to action, things change. There's no debating that. The question is, what constitutes a real change that would require design review and further planning commission approval? Is it just moving one cabinet 6 inches to the left? That seems extreme. Is it changing, I think you get my point. So I would urge the town to review that code and actually put something substantive there to avoid this issue down the line. Thank you.
Thank you. Next speaker, please.
There are no more speakers on Zoom.
Okay, so bringing back, I'll keep the public hearing open, and if we want the applicant or his attorney to respond to anything, or if the council has questions of either. Is Mr. Silverman still on? I don't see him.
Yes,
There he is.
Madam Mayor, I was coughing, so I spared you.
Oh, thank you.
But at least I'm not in the room with you coughing, so there's that.
Thank you for that.
I'll just briefly comment on a few things. I think the details matter, and while I understand the sentiment of, excuse me, maybe somebody could mute themselves. That the concerns expressed by several of the speakers, the public commenters, I think is a product of their not having the benefit of the information that the town council has before it, in terms of what happened with the original submission and permitting process, what details were shared then, what changes occurred, which go to the point that I think the last commenter made about how there is an ambiguity in the town code, and that led to the discussions that frankly were productive for some time between Mr. Friedman and Mr. Lockerbie. But ultimately there was a disagreement with that, and that's when the events that I've already described occurred. So I won't go into those again. The only other thing I'll mention that I think occurred to me as I heard the comments is that the timing here is also really important, because if Mr. Friedman had been given notice of these concerns that were raised this year, both in January and a few days ago, and if those were concerns that the town staff had back in June of 2020, we're talking about June of 2023 now, so a year and a half ago. the process could have taken a different path, and he could have not spent all the money that he spent on this project since then, to have a hearing now with these new issues raised and for the first time. I'll end with that. Thank you.
Thank you. Did Mr. Friedman want to comment at all? I see none. Do the council have any questions for Mr. Silverman? Go ahead, Councilmember Cutrano.
Yes. Thank you, Mr. Silverman, for attending and sharing the position of your client. Couple quick questions, because I'm kind of confused on the timing. You've referred on a number of occasions to learning about some of the concerns, or your client learning about some of the concerns this year. But you also pointed our attention to attachment E in the packet, which shows that in June of 2023, there were already discussions, maybe orally, but also then in writing, and there were agreements that plans would be submitted by your client in his words. And then there were public meetings that were held in the fall. The council actually heard another item as part of this saga. And at that time, I believe the mayor and other council members had already started to raise concerns at the council level about drainage issues, some of those other emails from neighbors. So I'm just kind of confused about.
If someone has their phone on, could you please
that-
put it on silent because we can hear it? I'm sorry.
Thanks.
Councilmember Cutrano.
So if you could help me understand where because there's a misunderstanding that I'm having where I participated in events last fall. We have documents between your client and staff from last spring and summer, and you are under the impression that we're just starting to talk about some of these concerns this year. So could you help me understand your perspective on that?
Sure. And I will confess that I was not personally involved in much of these events. But let me be clear. I'm not saying discussions about concerns at all started this year. What I'm describing is, the concerns that were actually raised leading up to the, albeit informal, agreement about what the town staff would allow to proceed and what they would not in June of 2023, at the working level, which ultimately broke down, and that's what led to the writ action where the judge rightly decided that if the town were going to prohibit the construction in total, that it needed to have what's called a pre-deprivation hearing, that the law requires that. And you could say that that's what this hearing is, except that we're post-deprivation at this point. We are now at the point where Mr. Friedman has been prevented from continuing his construction for entirely. Perhaps with some limited weatherization or winterization, but otherwise completely stopped since January. Objectively, if you just look at what the formal actions of the city have been and what the basis for those actions have stated, of the vast majority of the allegations in January and then a few days ago in the amended report are new. They were not what Mr. Lockerbie presented to Mr. Friedman in June of 2023 or since then until we got into this hearing process thanks to the court order.
Thank you. I have two more questions for now, and then maybe I'll reserve my comments for later. So where would you say, I know there's some folks in the community have shared their perspective on how far along the project is. Do you or your client have a percentage that you could share how far along? Say we didn't revoke the permits tonight and allowed the project to continue. How far along is the project on 0% to 100% by your estimation or your client's estimation?
I can tell you that Mr. Friedman would estimate that if he were permitted to complete the work, he would be done within 2 months, and that he estimates about, and this is not a scientific number, but 85% complete is the number he gave me.
Okay, thank you. That's helpful. Kind of follow up to that. I'm curious, can you confirm whether or not Frederick C. Devine Associates has been engaged to update the architectural plans, or whether ILS Associates has been approached to update the drainage and erosion control plans, or whether Herzog has been approached to update any of the geotechnical work that'll need to be brought back once that final 15% is completed?
I can't speak to those specific engineers, but I can say that Mr. Friedman is committed to getting properly licensed, having properly licensed engineers complete whatever detailed plans are needed to get the approval when he's done. So, I think when I say that, and he proposes that he be allowed to finish that last 15% and then submit for approval, and, hopefully convince the Planning Commission at that point, or the appropriate authorities to approve, that includes complete engineering where required.
And my final question is, at least for now, is your client actually working off of any plans right now for all of the new work that's being done, or is this just kind of building the plane as you're flying it sort of thing?
I'll say what I understand, but my understanding is he is working off of plans. He has submitted plans that, we've heard criticisms about what level of detail they have, but he did submit plans to Mr. Lockaby that shows what is being built, or what was being built until it was stopped, and so it's not put up framing and then draw a picture to show what was put up. There are plans that were submitted to Mr. Lockaby which show what is being built, or was being built, I should say.
But sorry, just one more quick thing to interject. So it's not, you can't confirm at this stage whether or not the plans are complete enough that your client would know whether or not any of the things they're building are to our code. Is that true?
I don't believe that's true. I believe that engineering has been done by licensed engineers. Whether that would be sufficient for final submission and approval, I can't say. But the structural engineers, and I honestly don't recall which of those three are the structural engineers, have remained engaged in the process. And when I say plans, these are not, I think there was a suggestion earlier that perhaps Mr. Friedman prepared the plans, and that is not true.
Okay, thank you. That's all my questions.
Other questions? I have a couple questions if others don't. Mr. Silverman, the plans that we've seen that Mr. Friedman submitted to Mark Lockaby were not signed by a licensed architect and engineer. Who drew those plans? And they were quite different from what was approved by the Planning Commission, and were a condition of approval that they must follow those plans. So who drew the plans that Mr. Friedman gave to Mark Lockaby? And were they there was no license signature on them.
So the plans do still need to be signed, and they do show the differences in what has been built from the original submitted plans. And I'm sorry, I was trying to think of all the things you asked, and I've
Well, it was
lost track.
really, my question is, what I saw were what looked like hand-drawn plans. There was no, they were not the typical, I sat on the planning commission for a couple of years, so I'm familiar with looking at plans. There was no signatures. There was no showing deviations from the original plans, not by Fred Devine Architects or anyone else. So I'm just wondering, do you know who drew those plans up?
I do not. I know they were, created in the AutoCAD program, and that they were, they need to be signed off by the engineers, and they have not yet been signed off by the engineers, and that would be something that would have to happen before they could be finally approved. That nobody contests otherwise. And that's all I know, sitting here.
Okay, I have a question. In December of 2023, our building official, Mark Lockaby, and this is attachment E, which you referenced before, sent an email to Mr. Friedman about certain things that could be done, certain things shouldn't be done. And Mr. Friedman did respond to those. I don't know the date that he responded, but looks like it's part of this email. Mr. Friedman got back saying, oh yes, June 7th, 2023, which is kind of interesting. So this was, Mark sent the email on December 15th, but it attaches Mr. Friedman's
If I may,
email.
Madam
Could
Mayor.
someone please turn their phone off? Oh, okay. Is that PD? Okay, so
If I may, Madam Mayor, I can
yes.
explain that to you. That December date is just when Mark printed it off. It's when.
Oh,
when
okay.
Linda
So
printed
it's,
it off.
so this is dated June 7th,
Yes.
2023, response by Mr. Friedman. And in this, Marx has a lot of things that he talks about, but at one point he says, near the end, please update your new plans to reflect the agreed upon deletions and work with the planning department for the changes that need planning commission approvals. And then he says, I will let you know that if any work is continued in the areas that need planning commission approvals, a stop work order will be issued. So Mr. Friedman responds, I intend to submit plans showing the changes when the project is done and for the county assessor's purpose only, so that the property can be assessed for tax purposes. If you'd like to show the plans to the planning commission, then be my guest. However, I don't agree that the planning commission should have anything to do with any work or changes relating to the ADU or JADU or with any other changes so long as the house complies with all the zoning standards. Are you familiar with that response by Mr. Friedman, which back in June made it clear that he was not interested in submitting new plans to the Planning Commission? A condition of his approval was that he follow the approved plans. Is there something that I'm missing here?
That was, there was a process of discussions, and at that time, Mr. Friedman, I believe, went further than he should have. But, there was a question at the time of which of the revisions were related to the JADU and the ADU, which would trigger the state law restrictions on what would be subject to more than ministerial review. And there was also this issue, which we've heard about already today a few times, and it's in the papers, about the timing of the final submission to the Planning Commission, with Mr. Friedman's view then and now that that the code does not require those to be submitted until the changes are done and the project is done. And then the last point he was making, which we still believe to be true, is there's nothing about the plans that violate, and I believe this is what he's referring to there, that violate any building code requirements. There's nothing, in the electrical that violates the electrical code, or those kinds of violations that the codes are compliant. So really, it's only a question of what were changes that ultimately would have to be approved by the Planning Commission, and what were changes related to an ADU or JADU, which were subject to ministerial approval at the Mr. Lockaby level.
Well, okay, so I respectfully disagree with some of what you stated. When people go to the Planning Commission, there is a process whereby the plans are reviewed. We have fire department and other agencies look at that. Neighbors get to weigh in with concerns. I would argue that moving the foundation 3 feet is probably a big change. I would argue that over excavating the basement is a pretty big change. And I don't think this is a matter of just process. I think that we need to have people, go back so that the Planning Commission, which is well versed in really looking at these kinds of changes and details, and I'm only teasing out a few, would have the opportunity to really work with those, and where it made sense, approve those changes. Where it doesn't make sense, don't. The other thing that concerns me is something I've heard from members of the audience. We'll just let him finish, and I've heard that as well from you. We have a hillside residential ordinance, which is important to weatherize in the winter. So I don't believe that any building could really be done at this point. Usually have to stop during winter so we don't cause sloughing. Now, I may be wrong on that, but I think we need to really look at that there was kind of a constant pattern of Mr. Lockaby trying to work with Mr. Friedman to get some work done that could be done, but that there was bigger picture items, and that's what's kind of come out. There's quite a detailed list, some of which you say are new, but I think having looked at the project overall, appears there's quite a few changes that appear pretty significant. Some may seem minor, but it's not moving a cabinet, as somebody said who provided comments. So I've asked my questions. I think no one else had questions on the council, or did you have a question, Bruce? Well, let's bring it back for deliberation.
Do you want to close the public hearing on it? Is that how that works?
Oh, yes, I'll close the public hearing. Thank you, Councilmember Catrano. So let's bring it back for deliberation.
So one thing I'd also add to to the comments that we've heard so far, along with questions, is that ministerial review of ADUs and JADUs, while required by the state that we do them by ministerial review, that still is a ministerial review. That doesn't mean you build one without any review. It means you come in, and I'll ask for staff's clarification or confirmation about this. But if someone were to want to add an ADU, they would come in with plans to do that, and then the ministerial review, the requirement of the state says that doesn't need to go through the Planning Commission. It can just be reviewed by staff, but it doesn't remove the requirement that you bring plans before you do the work. Is that correct?
Yeah, if someone wanted to build an ADU, they're supposed to come in with construction drawings that show how the ADU is going to be built.
Mm-hmm.
Yeah, and then they're reviewed by planning and they're reviewed by the building department.
Yeah. So my point is that just because some of this construction involves ADUs and JADUs does not mean that the construction should be done before anybody sees the plans or reviews them. I just find it baffling that anybody could honestly be confused as to the order in which things are done, whether you first bring the plans to staff and then build, or whether you first build and then bring the plans to staff for approval. That's what would be the point of the word approval in that second. I mean, it just doesn't make any sense that that would be a confusion. And I think it sounds to me like sort of willful stubbornness rather than confusion. But as has been pointed out in terms of how to resolve this, and it obviously gets difficult to figure out what to do when you've got a half-finished house and people are sick of seeing it there and so forth. But it seems like in terms of timing, if the applicant were to actually do what the town is asking and what has been repeatedly asked of them, which is to finish their plans, get the appropriate studies done or modified, which they did in the first place. They had the studies that they needed. They got them approved, but just get those studies modified by competent engineers to, among other things, but probably of primary importance, to protect public safety, because we do have a pretty severe landslide potential there. So get that done, bring it back to the Planning Commission on more or less the schedule that's already been proposed. And meanwhile, this is not, it's going to be raining for the next week as far as we know, and will probably continue. This is not the construction season. And we usually, if my understanding is correct, we usually don't allow large earth movements to be done in the winter. We have a specific construction season for that, and this is not that. So it seems like it's the logical thing to do, to get the plans approved, the new plans approved by the Planning Commission, and then resume construction and weatherize it to the extent necessary in the meanwhile. It seems fairly straightforward to me.
Okay,
I'll leave it at that for now.
thank you. Other members of the council have any comments for deliberation? Vice Mayor Blash?
Yeah, and I guess one thing that would be nice would be clarification about the choice to revoke rather than suspend. So that would be just useful for, somebody to lay that out. I just wanted to note that we received a lot of information from the council and for the person who is for Kobe Friedman, which just to me, it demonstrated just a huge amount of communication about this issue, 17 separate exhibits, nearly all with multiple parts, including numerous emails and letters. So it seems like a lot of communication has gone on about this for a very long time. I do have to say that, so it seems like the applicant has been given numerous chances. I really do hear the public when they say, you can't just build whatever and submit plans later. Like, why would we have a planning commission or a planning department if you can just submit things after the fact? There was a garage built on Wood Lane, I believe, and they were, I think, required to take it down. So it seems hardly fair that that household had to do that, whereas this one just keeps getting to move forward. And the thing that concerns me about some comments is that, we don't know what will happen with our planning or with our housing element, but, should there be new construction in town, we don't want to set a precedent where people come in with large projects and just build whatever and then submit the plans when they're done. So that just concerns me a little bit, setting a precedent. But I do also hear one of the neighbors saying that she's concerned about it getting done, and if there's a legal way to get it done or satisfy the legal side and still finish the project. So, I did hear that. The other thing that I am just curious about, is like we talked a little bit about the safety issues, and I looked at pictures that were sent to us by neighbors and others. First off, the concern about the excavation being very close to the property line and the structure of a neighbor's house. That looked a little concerning. So I'm wondering, what the issues are there. And this, and again, we talked about the whole thing being moved over 3 feet. And then, we've been hearing about a huge amount of water coming off of the property. That seems like, something that might have been mentioned as, there might be drainage issues prior, but, you're really going to see the drainage issues in January when there's a lot of rain. So I'm just curious about, how concerned we should be about the safety issues with this house. And that's all.
Okay, anyone else? Councilmember Hellman?
Yeah, sorry, I just gotta pull the muscle. I agree with my colleagues, and I just feel that it would be a really concerning precedent if we allowed construction to proceed, as Vice Mayor was saying. And it does, from everything that was submitted, it's very clear to me that there was a disregard for the process and the guidance he was given by our planning department. So yeah.
Thank you. Councilmember Cutrano?
Yeah, I thank you, Councilmember Ackerman, for laying a lot of this out so well. And the Vice Mayor for pulling back some of those materials too. That's been very helpful. I'm sort of surprised that like there would be even a consideration of for like just letting somebody build whatever they want with no sense of what those plans actually are, and then to just it's sort of a trust us sort of method that I mean, a number of y'all have mentioned the precedent, but it seems like really bad policy making. It just seems like bad for the entire community. But what's more, I'd be concerned both, for Kobe's sake or the applicant's sake, trying to build something and then run around with your unsigned plans looking for an engineer to sign off on something that they had no business in creating and that no one had reviewed. And then for the neighbors to live with the uncertainty that a project was erected and just not knowing if those plans were legit and wondering what attorney or what engineer or whomever signed off or put their stamp on it. I mean, there's so much uncertainty around the project that for the sake of literally all parties involved, I would I don't think we could go forward with business as usual, and I think we do need to move forward with the staff recommendation. And I'm happy to make a motion at the appropriate time.
I think it's a good time.
Okay. Well, I would, do we have a number on this? Is it just 2401? Is that the reso number?
It's 24 dash blank.
24 dash blank is,
I don't believe there's been a number assigned to this reso yet.
We don't sign numbers to resolutions until they've been formally adopted by the council.
okay. So will 24 dash blank suffice? Yes, but yes, I will. Adopt resolution, number 24 dash blank, a resolution of the Fairfax Town Council revoking and rescinding Planning Commission resolution number 2022-01 for application number 21-17, including approvals for a hill area residential development permit, design review permit, excavation permit, and tree removal permit, and a minimum and combined side yard setback and retaining wall height variances and accompanying building permits for a residence located at 79 Wood Lane with the amendments in the supplement and the amendment that Ms. Neal read into the record earlier this evening.
Would someone like to second that motion?
I'll second.
Okay, so that was Councilmember Cutrano and Councilmember Hellman. Madam Clerk, could you do a roll call vote?
Yes, Mayor. Councilmember Ackerman.
yes.
Councilmember Hellman.
Yes.
Councilmember Cutrano.
Yes.
Vice Mayor Blash.
Yes.
Mayor Kohler.
Yes.
All ayes.
Okay, and just a quick note, I'm hoping that staff will move forward working with Mr. Friedman on winterization. And with that, it's only 8 o'clock, but I think our next item is going to take a little while. So I suggest a 6-minute break. Let's be back here at, why don't we say 10 after 8, longer than 6 minutes. Thank you. Okay, if everyone could take their seats. We're going to move on to our regular agenda, and our item is discuss partial implementation for rent stabilization program, consider adoption of a resolution to start partial implementation of a rent stabilization program, and consider introduction of an ordinance to amend chapter 5.55 rent stabilization program of the town code. And sequel, this resolution and ordinance are exempt from California Environmental Quality Act pursuant to section 15061B3 of the state sequel guidelines. And I think I'm going to hand it off to our planning director, I'm sorry, now I can't even say your name anymore, Jeff Beiswinger.
Yes, thank you, Mayor Kohler and Town Council. Usually people have problems with my last name, but yeah.
Well, I've done that too.
Yeah. Anyway, this is a joint presentation. I'm going to go through a PowerPoint, and then also the town attorney is also available for questions.
And is the PowerPoint posted already online, or will it be?
It is posted.
It will be.
It will be. Okay.
Okay. Thank you very much.
And I will start sharing my screen. There we go. Okay, so this is to go over a staff recommendation for a rent stabilization program for the town of Fairfax, kind of a partial implementation. So the purpose tonight is to discuss this partial implementation, consider a resolution which would initiate it. And then there's also a minor amendment to an ordinance to establish a $1,000 fee for a hearing process. So we're trying to keep this kind of as simple and straightforward as possible to be able to do a partial implementation very soon. So first of all, just some basics on rent stabilization and what we're trying to achieve with our current ordinance. It applies to apartment units that are built prior to 1995. It also would apply to detached accessory dwelling units built prior to 1995. We made some recent amendments to exempt attached ADUs and JADUs. So with that, it does not apply to apartments built after 1995, single-family homes, condominiums, attached ADUs, and then also there was also a recent amendment to exempt single rooms that are within a home, so, such as like a single room inside a single-family house. So how can allowable rents be increased? There is a process. The first is if there's a new tenancy, if someone moves out of a unit and then a new person moves in, then there would be a new base rent established based on that first month's rent payment. And then the subsequent rent increases would be subject to what's called the annual general adjustment, or AGA for short. And that's the second way that rent can be increased, is every year there is a AGA established. It's based on the Consumer Price Index. It's calculated based on the March CPI, and then it goes into effect on September. So there also another recent change to the code. It was when the ordinance was first established, it established a 60% of a CPI rate. So the current rent increase could be 2.52, that's this year, and that's based on a 60% of the CPI of 4.2% from March to March. This coming September, the adjusted gross income will be 75% of the CPI, and again, based on kind of that the change from March to March of the year. And so that was also another recent change. And so this also requires that the housing provider request the increase prior to that going into effect. Then the third way that the rent can be increased, if a landlord wanted to increase it above the CPI, there would be a petition process. The petition process would also be available to a tenant who wanted to protest a rent increase. So staff is recommending a partial implementation. So what is the purpose? It's to initiate the program at a low cost prior to the November vote, which would be, as you may recall, this is on the ballot whether or not to keep the rent stabilization program, and that's going to be voted on in November. The key features of the program would be there would be no registration fees, and then there'd be $1,000 to file a petition. The key components of this would be a warm line for staff to be able to answer questions. Limited registration. If someone were to file a petition, those units would need to be registered, so we'd have something to base the petition on. And then the petition process, which would include a hearing examiner. So just to go through each of those kind of components of this partial implementation program. First component would be this in-house public outreach. We have a housing specialist, which has been previously budgeted for in the fiscal 2023, 2024 town budget. We just have not hired that position yet. We expect probably 1/4 to 1/2 of that person's time would be spent on the rent stabilization program. It would include kind of what we call a warm line for landlords and tenants. So somebody that would actually answer the phone and be able to walk people through the petition process or the rent stabilization program. And then there'd also be some additional outreach over the website that this person could work on. The second component of the partial implementation, staff would recommend getting a hearing examiner available under contract. We have identified an attorney with experience specifically with this type of petition process. We estimated on average, it would probably take between 3 and 4 hours, and a fee of $1,000 could mostly cover that cost. Staff would serve in a support role, which probably would not be covered under that $1,000 fee. So that'd be kind of an additional expense, but we don't expect that to be a large expense.
And just a clarification,
sure.
sorry to interrupt, but it's my understanding that the attorney is not affiliated at all with the Berkeley Rent Control Board or Leah Simon Weisberg, correct?
Correct.
Okay, thank you.
And so basically the purpose of the petition is that we're trying to seek a balance between protecting tenants from excessive rent increases and ensuring that the housing providers have a fair rate of return. The other component for the partial implementation is limited registration. And as I mentioned earlier, it's only as needed and it'd be paper-based. And the purpose of this would be if there is a petition, you need something to base the rent increases on. So you need to register the units that are subject to the petition so that you'd be able to calculate the appropriate rent increases and have a baseline. So there would be a kind of a general fund expense for kind of managing those files, which is why we'd want to keep it as kind of as simple as possible. So the advantages of this approach would be quick startup. We could start this program as early as early April, when the ordinance changes would go into effect. There'd be this would be a low cost implementation to basically try it out prior to the fall vote. There'd be no cost for most housing providers. Already, housing providers are entitled to the annual gross adjustment for rent, so they could increase their rent by that amount. And there would be a low cost for hearings if there was a need to exceed the annual general adjustment. If the costs were basically the cost of running the housing was exceeded the income, then there could be some petition process to request that additional rent increase. So the primary disadvantage is there could potentially be a low compliance rate. We do not have a registration system, so we don't have any way to really regulate rents, effective way to regulate rents in the town currently. And also and the paper-based system was somewhat cumbersome. It'd be much better to have kind of an electronic-based system, which could be more effective in managing registration and rent increases. So there is alternatives, potentially in future enhancements that could be available to make the program run more efficiently. One would be an option for additional staff. If we wanted to fully implement the program, it could be in-house staff or consultant help. And then there'd also be technology that we could add in the future in terms of a customer relation management system, which could be run over the internet, also direct web-based registration system. And, basically there is specialized software out there to design to manage rent stabilization programs. So the recommended actions for tonight is to discuss and receive public comments. And then we would recommend the adoption of a resolution which would set April 5th as the start date for partial implementation, establish a hearing process for the rent increases above the annual general adjustments, introduce a simple registration system, which would be paper-based, and have that informational telephone line available. The ordinance, we would also recommend that there'd be a waiver of the first reading and introduction of an ordinance, which would add that $1,000 petition fee, which will be paid by landlords for rent increases above the allowed amount, or if a tenant objects to a rent increase. And with that,
and I'd ask everyone to just be quiet so that we can hear. And
yeah, anyway, that concludes the presentation, and we are available for questions. Well, I should ask if the town attorney wants to add anything at this point.
No, I think you mentioned the resolution with the partial implementation date of April 5th, and that's required in the ordinance that we have a date and we have a resolution. And then there is an amendment to 5.55, chapter 5.55 of the town code that provides for a fee for hearings before a hearing examiner paid by the housing provider.
And just to clarify, one of the pieces that wasn't on your slides is along with housing provider requesting to raise the annual general adjustment, or a tenant, it can also be a complaint-based system, which is most of our systems. Correct. So if somebody hears of something happening, they can register a complaint as well. Correct?
Yes, correct.
Okay,
Or
just
correct.
turned off your
Yes.
mic. Okay,
Yeah.
so questions for Councilmember Catrano?
Yes. Thank you for this creative staff report here with these different options. I'm curious, well, one thing first, maybe to Town Attorney Colson, we had the different ways that rents can be increased currently. One is, at time of vacancy and a new tenant there's a new base rent, and that can be reestablished as the new rent. There's the AGA, or the adjustment for this year, which is a certain percentage of CPI. Then next year, it's a larger percentage of CPI at 75% of CPI. And then you had the petition process, but then there's also the private right of action, which is currently what folks could use if they were trying to get a fair rate of return or wanted to get an increase, right? So could you speak to that a little bit?
Sure. So the original ordinance provided for a hearing examiner and a hearing before a hearing examiner to ensure that the housing provider could make a reasonable rate of return. If they needed an increase higher than the allowed amount, the thought is they would bring the proof of I'm not making a reasonable rate of return. Here's the reasons why. Here's my insurance bill. Here's my electric bill. Here's my whatever. Here's my cost, and here's how much I actually need in rent increase. And that we would do that before a hearing examiner, and that decision would be appealable to the town council as an appeal body. And because we haven't implemented that section yet, we've made sure to ensure that housing providers could have a mechanism by which they can assure themselves that they can have a reasonable rate of return, and that's by making sure that it's clear that they have a private right of action. And so right now, until we get the whole hearing examiner and then appeals to council and all of that set up, there is definitely a private right of action, which means that if a housing provider raises the rent higher than the allowed amount, the tenant should probably pay that, but can also then take that to court and challenge that. And that provides the mechanism for the housing provider to demonstrate why they need that. So that becomes a private civil action. It's not something that the town has anything to do with, but when we get the ordinance fully implemented, then there is the thought that you will have the hearing examiner, you'll have the appeal to council, and that takes the place of a private right of action.
Thank you. And even you said fully implemented, but even partially implemented is what we're contemplating, that
Yes.
the hearing examiner process would be an alternative to the sort of classic American, everybody lawyer up and go to the courts and battle it out kind of thing.
Yes.
Okay. Thank you. That's helpful for folks to know, I think. One of the other questions I had relates to the fee. Jeff, if you'd be able to speak to the $1,000, it's 250 an hour is the estimate for the hearing examiner.
Isn't it 225?
225, sorry, my mistake.
Yeah.
But it's 3 to 4 hours, so it's
Total.
yeah, that's a deposit. So is that right? Or is
No,
that's
the
just
fee.
that's a fee?
That's
Okay.
the flat fee. And the thought is that according to the hearing examiner who has experience doing these types of hearings, 3 to 4 hours is the amount needed, including travel time, including a hearing that would be maybe an hour to no more than 2 hours, and then maybe an hour to write up a decision. That would be 4 hours. So 3 to 4 hours time is all that would be required for the average type of petition to have a hearing, because there's only one narrow issue that's really being looked at, and it's whether or not the housing provider has adequate justification for raising the rents above the allowed amount. Can the housing provider demonstrate that they're not making a reasonable rate of return without that?
Mm-hmm.
And before you go on, just to clarify, if it costs less than $1,000, the housing provider gets refunded that
Yes.
amount. And then if it costs more, the town eats it.
The town pays for it. Now, that's the way it's written. You can change that. You can
Okay,
modify it, but
just want to get the facts out right now. So
Yeah,
sorry,
that's a
Councilman.
great
Meaning
question.
if the hearing examiner only used 2 hours, then they would get refunded
They would
correct,
get refunded the difference. So
1,000
it's
minus the 450,
and
what have you.
yeah. So
Yeah.
if it's costs $2,000, we won't be asking them for the extra 1,000.
right.
Go
Thank
ahead.
you for clarifying, because I think I was using that word deposit and that was probably the wrong word, but I think what you were just getting to, Madam Mayor, was exactly what I was wondering, whether or not if it's quicker, if the documents are presented and it's a very clear case, then that money ends up going back to the petitioner essentially.
The housing provider,
Yeah, yes, yeah.
landlord, yeah.
The other question I had was related to the limited registration, which is, Jeff, you mentioned the paper system, and it's based on a presumption of the number of petitions that would come in and whatnot. I'm curious, I know, but then you mentioned like other digital systems. Just, I think it's good for everybody to understand the cost of what you're bringing for, or what's being brought forward by staff, which is about $5,000 is the estimated cost of this particular staff recommendation. Is that right? Plus staff time?
Well, I think the recommendation tonight is just to do a basic paper-based system, just kind of a simple application process, and we would just
Right.
keep it in a manila folder.
In the chart you have on page 5, it says estimated annual cost. or town expenses is $5,000, but
Yeah, I think the next step would be if you were to take this basic startup and then you were to add something, the next thing you'd want to add would be kind of that $5,000 system, which would help do a simple CRM or management system, which could be web-based.
like a digital records retention type of
Exactly. It
thing.
would still be pretty basic, but it would kind of be able to have some basic functionality, which would help start the electronic registration process.
So based
Got it.
on your chart, it says $10,000 for
Okay,
that
yeah.
next. And then if you went the full boat, it's 25.
Got it.
And plus
And then
24.
that is just sort of leading to this question, maybe Town Manager Abrams, I know that the town of San Anselmo has already done this process for their business licenses for rental units, that they have a digital system, but is that what Jeff is speaking to? Like these are like in a future world where things are way more organized and not paper-based, there's like a CRM system, and other communities nearby have done these sorts of things?
This is a future world, but it is not what San Anselmo is doing now. I want to just make sure everyone is clear. These are estimates that
Speak a little closer.
yeah. So this CRM taking in rental information that's being referred to doesn't exist in the county right now, except the county has a form of registration for just cause eviction. And that's another layer that we could consider. It is not built for rent stabilization. So this is something where the first recommendation is do something which is very low cost, which is paper-based. And then assuming the program continues, we would definitely want to come back with a more robust system, assuming that there would be more units touched, right? Because right now we're just talking about people who want to petition for a rent increase above the allowable amount. So we expect that to be a pretty small universe.
Got it. Just to be clear, there's a different system in the future that's contemplated that could be entertained by a future council, and that system could be technology based, and that could be up to $200,000. But the system that's being presented, or the idea that's being presented tonight, is it a $5,000 plus labor costs of existing staff? Am I reading this chart right? I guess I just am trying to understand alongside the
Can I
public
just
what's the
interrupt?
cost.
The chart is for everything in option A is $5,000 plus labor costs. It's not just the paper system.
But it's correct, everything.
Right.
Yes, but
yes.
Okay, thank you. I think that's all my questions for now, but I was just trying to get a sense of the total cost you're talking about here, but thank you.
I have,
Councilmember Howland?
this may be redundant, so forgive me, but I just want
I
to,
don't think you're speaking close enough to the mic.
this may be redundant to Councilmember Cutrano's first question, but I just want to make sure that we have a common understanding. So current state, since the ordinances, or the ordinance in this case, rent stabilization, was passed, there is no simple administrative process for a landlord to substantiate that their costs exceed or substantiate a rent increase over the cap that exceeds the cap. So if I was a landlord and I had replaced my roof, some other capital costs or PG&E we're hearing, water, et cetera, and I wanted to raise my rent 3% instead of the allowable 2.52 right now. There's no simple administrative process currently for a landlord to submit their costs, et cetera, to substantiate that rent increase. Is that correct? correct. Okay, so this partial implementation of $5,000 fiscal costs plus labor is to support a petition process that doesn't exist today, correct?
Correct.
Because today, as Councilmember Catrano explained, either the landlord or the tenant is required to take some type of legal action, which, obviously requires getting a lawyer. And
Yes.
most lawyers.
Costs more than $1,000.
Yeah.
Yeah.
Okay. Yeah. I think that's it for me for right now. Thank you.
Okay, Vice Mayor Blash?
Yeah, I just wanted to check a little because, I mean, I, heard a lot from people concerned about the different options that are being presented, but tonight we're really only considering a resolution to adopt option A. We're not debating the different options, right?
Right. So the intent was to bring you an option that was actionable quickly and relatively with relatively low expense.
Mhm.
And that would be an opportunity really to over the next 6 months before any sort of vote was had, that people could experience that and
So I
be
just
able
want to
provide that
remind
service.
you got to speak a lot closer to the mic. We can hear you, but I'm not sure that folks in the back of the room can.
Yeah, thank you. Yeah, so the other thing I just wanted to clarify, so, I look at this chart, there's a town cost that says $10,000 third quarter, not included in total below, and then there's additional costs, 5,000 plus labor costs. What's the difference between those two?
I can explain that a little bit. So the idea was to kind of present the town council with kind of the full picture. So in addition to the hearing examiner cost, there is going to be incidental costs related to staff support and all of that other thing. So we don't expect the entire petition cost to be covered by the $1,000 fee.
Right.
There will be some additional costs. So we just wanted to capture that. That's the purpose for the $5,000. Is to recognize that there will be petitions that will go over 1,000, but there's also the support costs that go along with it. So just to recognize that there is kind of an internal staffing cost to implementing the program as well.
So is the real cost 10,000? Is the real cost 15,000? What?
I think the real cost without any sort of, if you just stick with the paper system and don't try to do anything additional to make the process more efficient with technology, then it could probably be kept to $5,000.
And if nobody
Or less.
applies during that period, what happens? What
Then
costs are incurred?
there would be only the cost of calculating the annual general adjustment.
And the warm line.
And the warm line,
I just
yeah.
want to clarify, this chart, basically the $10,000 that you have here, looking at your chart, and this is on option A, you say staff recommends the start of a proactive registration in January of 2025. And that's with the understanding that there's a possibility that the ballot initiative won't pass. Should it pass, this wouldn't start. But this could involve the utilization of a simple web-based platform for registration of apartment units. And that's where you have town cost of $10,000. It's a little confusing to have that in here.
Yeah.
I think what you're talking about with option A, and I'm sorry to interrupt, but I think that put a layer of confusion in, is basically we're talking about a warm line answered by our existing staff that'll be starting soon, that'll be working on the housing element work, as well as this, if we approve this, the registration, which would be paper registration, this hearing examiner approach with the $1,000 fee, and what our costs would be under that option without starting anything in January 2025 would be 5,000 plus labor costs and
Yes.
some additional stuff. Is that correct?
That is correct. Yeah, the
Okay,
10,000
so it's just a little confusing. I'm sorry to interrupt you, Vice Mayor Blash.
No, that's good because I think it is confusing. And I was, hearing from the public various figures thrown around because people were a little confused about what was being suggested. And then I know that this is something where a rental property owner could petition to raise their rent above the cap in the interim between now and November, right? So we know that that is one way. Now, when you say that a tenant can petition, that means that somebody who received, say, more than the 2.25% in rent increase could bring it and complain, or like how would the tenant end up petitioning?
It's contemplated that they could also file a petition for a hearing or a request for a hearing to have kind of a prove up or a showing.
I don't appreciate people yelling. Janet, you need to speak more closely into the mic. Everyone over at that side of the table, bite that mic, please.
Okay, so yes, there is the ability of a tenant, if they receive an increase over the allowed amount, to basically complain or to request a hearing to have a prove up or a showing of why that is an acceptable amount, why that amount is needed in order for the landlord to secure a reasonable rate of return.
Right. So then, but then the landlord pays the $1,000 fee because basically they went against the law that was in existence and
Well,
they needed to.
The thought is that they're the
cover
ones
that.
requesting over the allowed amount.
Okay. I think that's all of my questions right now. I just kind of wanted to clarify some of these so that it was a little easier to understand.
Thank you. Any other questions from staff? Of staff from the council? See none. I'd like to open the public comment period. There's a lot of folks in this room and there's a lot of folks on Zoom. So we will be staying with 2 minutes. And so first speaker, come to the mic, please.
Thank you, Madam Mayor. Rick Hamer, downtown Fairfax. This is a really important thing to do that, I know that there's a lot of support everywhere for it. But I'll jump right to the one thing. If you've already read my emails, on page 2 of the ordinance itself is really the gist of the matter here. It says landlord shall pay a fee of $1,000 to petition for a rent increase adjustment. I would like the council to consider that instead of saying $1,000 to petition, to at least say at the time of the petition hearing. In other words, this gives the warm line petition phase, when it's done by staff, to be done at no charge for a petitioner, because at that time the legal hearing officer has not yet been hired and the cost is not yet incurred. So I think that would help this go down a whole lot easier with landlords.
Thank you.
Thank you.
Next speaker, please. Wendy Baker, 235 Scenic Road. I'm here tonight with a new motto for the council, which is just say no. Our dear friend Nancy Reagan came up with that. And I'm hoping that you will say no tonight to spending money on this ordinance that I think is going to be defeated in November. I was just looking at the public packet of emails, and I think there were 2 or 3 people in favor of this ordinance and probably 20 against, which I think might reflect the audience that's here tonight. I'm was a renter for 25 years in Fairfax, and when this ordinance came up, I thought, well, what problem are we trying to solve? When I was renting in the 70s and 80s, paying about $300, I was doing internships as a landscape architect, and I would be in between jobs frequently. And every now and then I'd have to borrow rent money. And in those days, you could borrow $300 from a friend. Well, we live in a different world right now. $3,000 is what the rent is. And these percentages of increase aren't really solving any problem. We already have a state law with a rent percentage increase. But when you're talking about $3,000 for rent and you're talking about 2 to 3% increase, it's not solving any real problem.
So the just say no, let's see, 17 seconds. I just hope that some of you will say no. I'm always surprised that all 5 of you keep voting these things in that so many in the public do not want. Thank you.
Thank you. Next week. Okay, all right. There will be no applause. It's disrupting the meeting. Please let folks speak and move on. Okay, next speaker, Frank Egger.
Frank Aker from the Cascades. Fairfax is jumping the gun here. Why would Fairfax hire a new employee to enforce 2 ordinances that may be overturned by voters in November? 8 months from now. Larkspur approved a rent stabilization law. It was challenged by referendum, and next Tuesday, Larkspur votes to either uphold rent stabilization or reject it. Fairfax voters qualified an initiative to reject Fairfax's new rental laws and return to current state rental laws. It should have been on next week's primary election ballot right here in Fairfax. A $1,000 appeal fee creates a barrier for both tenants and property owners to have their grievances heard by an appellant agency or an appeal czar. Will $1,000 be the highest appeal fee at Fairfax Town Hall? I don't know of anything that's that high right now. I urge you to continue this item until after the November election, when we will know whether or not Fairfax's rental ordinance will remain in effect. Thank you very much.
Thank you. Next, please stop applauding. For folks who don't get applauded, they're going to feel bad. So let's move forward. And you know what? I am tired of this yelling. Let's keep it civil. We are all neighbors here. Okay, next speaker, please.
Good evening, Mayor and council members. I'm Susan Malloy, and
Can you guys keep it down? We need her to be able to speak, and we need to give everybody respect as we gave the prior 2 speakers. Thank you.
I'm thankful that on tonight's agenda that you are considering how to start up and a tenant how to start up the tenant protection program. I'm optimistic that the plan you choose will benefit our all our community members, be they renters, landlords, or homeowners. I'm one of the lucky ones. I'm a low-income senior who lives in Bennett House. But I feel responsible to help other tenants who are not so fortunate. I volunteer with St. Rita's, St. Vincent de Paul Conference, and we help people in Fairfax and the Valley who need emergency help. Many people in our community are poor and struggling. This past fiscal year, we provided $7,500 in rental assistance and $38,000 in food assistance to the community. And for the first 5 months of this fiscal year, we provided $4,500 in rent assistance and
Your mic turned off. Go ahead.
okay, thank you.
Please
Well, I'm going to
continue.
give you a few more seconds.
Okay. Our rent assistance is modest, as most of the rental assistance to people in our county come from the big nonprofit organizations that are centralized. But we can offer a little flexible help for people who can't wait until the big nonprofits get to them. We visit people when we provide aid, and we've visited people who are living in illegal units in which landlords will only accept cash for rent. and those that operate quasi boarding houses by renting out several rooms in their home. And often we find seniors have to manage with Social Security payments that don't even cover the rent. So the need is great. It's an important thing that you're doing. And let's get the ball rolling and tenant protection.
Thank
you.
Next speaker, please. Michael?
Thank you. I'm Michael Sexton, one of the directors of the Bruton Residence and FairfaxResidence.org. Thank you for putting those options for extra rent control.
Speak closer to the mic.
Thank you for putting those options for extra rent control out into the public. But quite frankly, I'm livid. And quite frankly, you have audacity. And the options are an embarrassment. Once again, you fail to recognize basic economics. First of all, rents are determined not by the owner's expense, but rather is determined by supply and demand and competition forces. Once again, you also fail to recognize that studies indicate that extra rent control in general does nothing to help housing affordability. In fact, extra rent control helps decrease rental options and increase pressure on rents for all tenants. Now, no matter how you run your numbers, you're asking every tax-paying resident to help fund this boondoggle for no direct benefit. You've allocated taxpayer funds to hiring a special housing specialist to the tune of $209,000 a year. On any of the options that you propose, $50,000 to $100,000 of their time will be spent working on any extra rent control implementation. That's in this the agenda. In addition to some of the options where you hire another full-time employee at $135,000 a year just for rent control, and anywhere from $20,000 to $75,000 a year for landlord and tenant registration database and other administrative costs. We're talking anywhere between $60,000 and $300,000 a year to implement this rent control implementation by your own estimates. You've laid out all these options in your plan, but the best option is not here. The best option is to do nothing until the November vote. Do nothing until voters decide whether they want to spend $209,000 a year on an administrator, and that's better than spending $209,000 on fixing the streets, on a better ball field, on helping improve downtown businesses, on providing recreational opportunities, on police, city services, and actually cleaning up mattresses that the homeless leave behind.
Thank you.
Thank you.
Please stop applauding. Next speaker, please.
Hi there, Philip Solivari, Fairfax. I appreciate your agenda packet having only 10 pages. That's a nice improvement. You offered three things, option A, B, and C. Tonight, only A was discussed. And to pick up on what Michael said a moment ago, you left out a very important option that wasn't in the packet, and that's doing nothing. Why would you spend what you consider to be a small amount of money, $5,000, and staff time on something that may go down in 8 months from now? Why? It makes no sense. $1,000 may be a small amount of money to you who sit up there on the dais to bring a petition before a hearing examiner. But for me, that's a significant amount of money, and I wouldn't do it. As Michael has pointed out, rent is determined by market forces, something none of you up there have really grasped yet. And the more rent control is in place, the more units go off the market, whether they become Airbnbs or they sit vacant. And I know one of you up there, actually it was Councilman Catrano, suggested a vacancy tax. This was a year ago before the initiative was put forth. So I think that these are the things that you're missing. And I would also just like to point out to you, Madam Mayor, you voted no against for just cause. And I know we're not discussing just cause here tonight, but I ask you to go back and stop agreeing with these people and stop working with these other council members. We don't need everybody to put a rubber stamp on everything. If you don't think just cause is right, stand up for it and refuse to participate in it. Thank you.
Thank you. Please stop clapping. Next speaker.
Nick Calder, Cascade Drive, and I agree with almost everything everybody said so far. It seems to be a very unpopular move to do what you're proposing, and I can't see why it can't wait until November to be implemented. I didn't know that these ordinances were going into effect until after they'd happened, and I was told that it was too difficult to let people know that this was happening and to contact landlords. And a few months after this happened, I got a postcard to tell me that I couldn't use my gas mower. Every household in Fairfax got one of those. So you can do it for a lawnmower, but you can't do it for something like this. I'm a housing provider, and your ordinances, they scare me, frankly. And I've moved a family member into one of my rentals, so it's not helping the people that you are trying to help. So I agree that I think it should be put off until November. I think if it gets defeated in November, you will have wasted a vast amount of our money, which we don't have to waste. It'll feel like the Cascade line striping, only worse. Thanks.
Thank you. Next speaker, please.
Good
Susan.
evening. Susan Adams. And I applaud the town council and staff's approach proposed tonight for implementing as much as reasonably possible in this manner to get the program underway and to see how it's operating. So that's one point I'd like to make. The second is I support hiring in-house staff because rather than the outside consultants, because I believe it is less costly to the town and the public in that regard. Over time, the experiences gained by in-house staff will stay and be passed on to additional staff, and to build up a detailed knowledge of how the ordinance will operate and can more efficiently assist both housing providers and tenants in getting answers to questions. And will be the people in-house who will understand what sorts of changes may be or tweaks might be necessary to improve the ordinance to better operate within the town. And again, thank you very much for doing this. I'm a homeowner and I support this.
Hi, my name is Lori Kramer and I live at.
You need to speak closer to the mic. Thank you.
Hi, my name is Lori Kramer. I've lived at 19 Taylor Drive for 21 years. And my message is simple. I don't think that we should spend another dime on this until it comes to a vote. I don't think we should spend any additional staff time because staff time is money as well. And you're not calculating that, but time is money. And that could be spent on so many better things than something that may or may not pass in a few months' time. So please just wait until we have a vote and can tell you what we would like to do or not do before you waste any more money on this. Thank you.
Thank you. Please stop. Okay, next speaker, Cindy Swift. You're going to have to lower that mic.
Thank you. So you've said my name. I don't understand, like everybody else, why this council is pursuing this action tonight when in November there's a referendum that may overturn the ordinances. This is a poor use of town staff resources and funds, which are the communities and community resources. So I ask that you wait till after the November election to see where we are as far as rent stabilization. Thank you.
Okay, next speaker, please.
Hi, Liliana Levezzo. I am pro rent stabilization. I am the president of the Lanai Tenants Association, and we fought back the illegal rent increases that occurred at our complex. There was about 30
You need
people.
to speak directly to council.
There was about 30 people that live in that complex. A lot of the people that live in these places are low income like myself. They're disabled, they're on a fixed income, and they can't afford a $100 rent increase or more than the 2.52%. I understand that people who are landlords want to make money I had parents that were landlords and we were able to have an apartment where we were able to make money. So folks, worse, I'd like to say is that it's not our job as tenants, low-income tenants, people of Marin County, to make sure that landlords are having money in their coffers for when they retire. If you're concerned about that, make sure you diversify your portfolio, but do not do it on the backs of working hard people who are trying to struggle and live in Marin County, which used to be affordable until all these rich people came in and made the cost of living in Marin rise up. I think it is right for people who are landlords to make money. I'm not disputing that, but I'm saying
Please
we
be
need.
quiet.
But what
the
I'm
audience.
saying is we need to make sure that everyone can live in Marin and it's not just the rich who are living off the backs of the low income. There are people in my apartment complex that are disabled. My sister, she's disabled. She hardly makes any money. And then we expect to have an illegal rent increase where we can't afford. Who do you think is going to be working at the grocery store or at the local coffee shop or down at the restaurant where you go and frequent and spend money? If the rent goes up, they're not going to be able to afford to live here. That's all I have to say. And we beat the law against that woman who lives not even in California, and she's making at least, I did the numbers, she's making money, and she's for this rent increase. I am not. Thank you so much.
I just want to say, let's be respectful to everybody that's speaking. If you don't agree, if you do agree, just please let people have their time, and, you can disagree, but please don't speak while other people are speaking. Thank you, Candace.
Candace Neal Ricker, born and raised in Fairfax, low-income tenant in Fairfax, property manager, or used to be. I'm up here to talk about why we're called a special meeting on Leap Day on a Thursday, when we've had 15 months of regular meetings to discuss this, when a lot more of the public would have been aware of a meeting. I don't find that very transparent, and I did my best to get the message out, and I appreciate Liesl's message on social media. In response to the Lanai apartment complaints and the response of Leah Simon Weisberg and Chance and Stephanie showing up for a protest, I doubt most of the people involved realize that Lanai Apartments builds in their water and gas in their rent. And as we all know in this room, what we are paying now for water and gas since last July. So if a $100 increase on a $1,900 a month apartment is over the 2.52%, what do you think the actual math is on what the actual water bill and gas bill are for that each apartment? And I doubt any of you are aware that the owner of that building, due to the stress of being sued by the Berkeley Rental Authority and Leah Simon Weisberg, had a massive medical condition, and she has stepped back. This has caused a lot of stress, duress, divisiveness in our town. We won the right to vote on this with our ballot initiative. I respectfully implore all of you to respect the aspects of democracy and the rights of voters. We have a lot that we need to get fixed in this town. The pothole right on the main crosswalk going to the coffee roasters is deep enough to break an ankle or knock a kid off an e-bike and get hurt seriously. There's small things we can do with $5,000 right now. That's what I ask you to spend that money on, and to respect the voters' decisions that will come. And by the way, that was all of your decisions to put it to November of 2024. We asked for immediacy, a special election, the March election that is now here. So please, I'm asking you all to consider everything I just said. Thank you.
Thank you. Next speaker, please.
Hi, Liz Frauenberger, Fairfax. So I have a couple of technical questions here. On page 4, second paragraph, the last sentence, you say ordinance 871, blah, 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 ordinance 871 is replaced in the vote. I think you meant repealed. I'm not sure, but I think that's a typo. Other thing else is, and I'm sorry, I don't have the page number, but under ordinance, it says the ordinance amendment is included for consideration of first reading, et cetera, et cetera. But then it says, if they want to, the $1,000 will be paid by the landlord if the landlord wants to make that petition, or if the tenant desires to object to the rent increase. While you said this would only be for asking about, saying, hey, they're raising it more than it's legal, I would like to see that language clarified, because otherwise the tenant can basically say, I object to this. So if we could get that fixed, that'd be great. Of course, overall, I wish y'all wouldn't do anything. I think you ought to wait till November. Then I had a couple of questions that came up during the conversation. Do we need a lawyer? It sounds to me like all we need is somebody who can do numbers. I mean, it sounds to me like we just need a bookkeeper, frankly, if you're going to do this. I don't know why we need a lawyer. And travel time, what's wrong with Zoom? And is there a metric that we're using for a reasonable rate of return? I don't think I've ever read that anywhere, but I could be wrong. And I already told you what I think about just hanging on till November. Thanks.
Thank you, Liz. Next speaker, please, Joe.
Thank you. Good evening, Council. Thank you for bringing this agenda item of implementation forward. I applaud you for taking this critical step to provide information and clarity on how to proceed for both renters and landlords in regards to the rent stabilization ordinance. The recent illegal rent increases that went on for over a year after the ordinance was passed by the landlord of the Lanai Apartments, Kathy Canine Black, who is an out-of-state corporate landlord who happens to be a top-tier donor for the campaign to repeal this ordinance in November, so who is well aware of the stabilization ordinance. That left a large group of our neighbors at Lanai on the brink of displacement and a state of long-term stress, with brutal financial choices they had to make to meet their basic needs. This is a prime example, the one large-scale example we know of, as there may be other illegal increases that drove working families out of town over the last year. It's an example of why we need mechanisms locked in where people have a place to turn at town hall when landlords attempt to make illegal rent increases, and where landlords can appeal if they are not reaching the reasonable return threshold. I ask that that your plan tonight for implementation be as comprehensive as possible and handled internally by our capable town staff and not outside consultants. But most importantly, you must adopt at least interim steps tonight, which are available to you right now as outlined in the staff report, while you continue to flesh out the longer-term implementation plan. This is our only way to ensure that all of our neighbors in Fairfax can feel true safety and security under the ordinance. If not, there will be more illegal increases and more daily anguish for working families and seniors as they try to fend off displacement. Thank you.
Thank you. Next speaker, please.
Hi. I also believe that you should not do anything with this tonight and that you should wait until the voters have their say in November. But I do want to point out that HUD, Housing and Urban Development, in 1974 started the Voucher 8 program. And in doing so, Marin County has an office that has overseen this. They have a rental schedule in their office, and it's substantial. It might be more substantial than you realize, but it would certainly be a good thing to look at. And by the way, they did, as of the beginning of this year, change their rental schedule from last year to this year with a 10% increase. Now, this has had a lot of input by their appraisers and by their staff, and they've been running this program for 30 years or so. So I think you should look at that and take a serious look at that, because if they feel it's 10%, where do you guys feel that the cost of living increases for housing people, including the utilities, including the maintenance, including everything that goes into it, is 2.75% or something? When we're getting 100% increase on the fire insurance, which, oh, by the way, you should be spending a lot of time on trying to help with that situation. People are calling constantly saying, I've lost my fire insurance. And oh, by the way, the Cal Fire requires that the roof be less than 25 years old. So if you have a roof over 25 years and you have no fire insurance, and now you have a federal loan that needs insurance, yikes. And that's what these towns should be spending some time on, trying to help with these kinds of situations. It impacts us all.
Thank you. No clapping, please. Next speaker, please.
Hello, my name is Jessica Lashbrook. I was born and raised in Fairfax. I would like to address the fact that not all homeowners are rich. I sadly just inherited my mom's house. I've lived in there all my life. It was reassessed mistakenly, which I was able to turn around. However, in that reassessment, the insurance went up $12,000 on top of the normal $4,000 annually. Not only did that happen, but the insurance didn't carry over. So fire insurance is $9,000 only, fire. Then on top of that is another $4,000 plus for regular insurance. Then the utilities. Last month, I, by the way, only keep my home heat nothing above 65. The utilities were for 2 months $1,000 plus. Shall we now talk about water and what is happening with our water utilities? It is absolutely horrible. I can't even speak. It's deplorable. It's deplorable. So I have to rent in order to stay here. I am scared to rent because if I rent and through COVID, it was proven that renters could just say, oh, I'm sorry, I can't pay, but you still have to pay your homeowner's insurance and your mortgage and everything else. But because I can't pay, I still can stay here.
Thank you.
So I'll lose my house.
Thank you.
That is why we
Please stop
can't.
clapping. Next speaker. Next speaker, please. Please sit
Mark
down.
Bell, Fairfax. From the letter that the woman at the Lanai wrote, no one called her about her rent increase being above. I don't know. And maybe you could have called her instead of calling what's her face over at the Berkeley Rent Board and driving over here to protest. Okay, so you're looking at $1,000 fee to try to get a raise above your limit. That's the equivalent of $83 a month, which probably is about what the person is trying to get. Larkspur estimate to put in the system, the type of system that you're talking about is $400,000 a year. You're looking at over 200,000. That's another $130,000 a year employee plus whatever technical stuff. That's $650,000 in 5 years. That sure is a lot of roads, isn't it? So why does this whole process have to cost anything? We have a planning commission, don't we? You could have a rent commission. You could have 2 renters, 2 landlords, and one who's not either. What's the cost? 0. Because for the most part, what you're looking at is, this is what happened to me this year. This is what I've spent on the property. This is like what I cover. This is like how much that has gone up. And when you're telling me that 2.75% is all I can raise, I'm not making a profit. That's pretty simple. You can probably even get high school kids in statistics to do it as a class project for free.
Mallory, your light is really blinding.
There's also no need for everyone's financial records. For the same reasons I stated, it's very clear. It's a black and white
Thank you, Mark.
situation.
Thank
That's
you.
about it. And Jessica covered the other things I was going.
Thank you. Next speaker, please stop clapping.
Hi, I'm
Okay.
Jeremy LeBeau. I'm a realtor. I live in Fairfax. I grew up in Berkeley and I work in Marin and I still work in Berkeley too. And I property manage 54 different units all over the Bay Area. I'm strongly against additional rent control laws here. If you limit rent increases, landlords will maximize their rent increase. That's what I've noticed. They want, because if they don't, then they're gonna lose out on the next increase and the next increase. So they need to keep on increasing it. You'll actually end up with more rent that the tenants are paying. When landlords are getting their fair market value or close to it, they don't want to increase. They run the risk of tenants vacating, which is the biggest expense they usually have to incur. So they try to keep the tenants happy. They try to keep rents okay. It's not in their nature to try to increase rents dramatically. So it just doesn't make sense why you would want to limit it, especially with the new laws that have already gone into place in California. So it's going to do the opposite of what you're looking to do. It's also going to discourage people from adding additional units in the area. People are scared to build here. I've talked to a lot of different clients that don't want to own multi-unit properties in this area, don't want to build multi-unit properties here. And just because of that threat. I think that rentals are meant to be rented for a definite amount of time, unless otherwise agreed to. You're taking away owners' rights, owners' ownership. And that just doesn't make any sense to me. I think that they should have the ability to do what they want with their property. And I also think that most people who aren't landlords just don't know that there are rent control rules. And I think you need to inform them a little bit better about
Thank
what
you.
exists.
Thank you very
Thanks.
much. Next speaker, please, Kelly.
Kelly London. I just want to say malarkey. Your socialism doesn't work. The open market works better. When you guys mess with the market, cost of rents go up, less housing will be available for rentals. Fix the roads, the sidewalks, and clean up the park for the kids. Quit wasting our money. Thank you.
Next speaker, please.
Hi there, Todd Greenberg, downtown Fairfax. Want to just make everybody aware of relative expenses in this town being authorized and not authorized by this town council. There's a $500,000 a year budget for streets, which this town council wants to increase everybody's taxes by $30 to $60 million. And they're spending $25,000 to study on how to do it. Meanwhile, the city of Larkspur anticipates the cost to be $400,000, which this town council and these staff reports don't properly portray for implementing rent control. How many people with your rent ordinances have actually had an issue? We know one of the issues, and we know the damage that it has caused to the owner who had a very reasonable rent increase. How many people are being injured or killed by your actions? Rose Tabor, in having to move out, is now in a skilled nursing facility. No, thank you, Fairfax Town Council. Are you aware that $400,000, which is a more concrete estimate than this town council is willing to be transparent with, is 80% of the street budget here in Fairfax? Are you aware that what you're proposing to adopt tonight amounts to a 4.2% charge for somebody paying $2,000 a month in rent, or for the property owner? Who is going to absorb that cost increase? Where is the common sense here? Who does not know how to do basic math?
Thank you. Next speaker, please. Deb.
Deb London, Fairfax. First thing I want to say is I agree with Frank Egger. Wait until the results of the November election. It's absolutely insane to spend one more penny of our hard-earned tax dollars. You got to wait. I support Michael Mack's letter to you. Wow, spot on. Talia's letter to you, incredible. This whole concept of a reasonable rate of return is absurd. It's absurd. It's the most unreasonable rate of return. Every year we go deeper and deeper and deeper into debt. Like Jessica said, our bills are through the roofs. Nobody's getting rich. We have the same special groups of people who are disabled, who are elderly. We're not, we're all mom and pops here in Fairfax. And and your little thing, I don't know who you are, sir, but you had your primary advantage was the 2.5% rent increase. That was a joke. And the primary disadvantage was spending hundreds of thousands of dollars of our hard-earned money on this implementation. I didn't see that in that column. And Barbara, if somebody hears about something going not quite right, it's like a watchdog thing, like the Nazis did in Germany. That's ridiculous. And Liesel, you are resting on your haunches of it's always a lot of unrest until
Sam,
things.
please don't call out people.
Well, I have to.
No,
I have
you
to.
make your comment. Okay,
to.
I'm gonna,
Okay,
I'm gonna
stop the
ask that the
clock.
room be
Stop the
cleared. We will
clock.
take a break.
Stop the clock.
Deb, just please make your comments and
Okay.
don't.
But I think that it's not right for certain people up there to to rest on their haunches and think, oh, well, it'll be okay after it all blows over. It's not going to blow over. We're not going to sit down, lay down, bend over, back away. We're going to gnaw on this like a dog on a bone. We're going to gnaw on your necks until we get you out of here. I'm so angry about this ridiculous thing you proposed.
Thank you, Deb. Okay. Okay, I'm going to ask that the room be cleared. If we don't stop this, please, let's go through this. Let's get our comments out. Sir, would you please step up to the mic?
I'm Dave Bronco, and I'm a landlord here or I'm a housing provider here in Fairfax. And I have tenants that have been renting here from me for 10 years, and for many years, I don't raise their rent.
Thank you, Mark.
I don't raise their rent every year, but this is forcing me to have to raise rent every year. And what was said earlier by the gentleman before who said that landlords want to take care of their tenants, and I do. And I do take great care of my tenants, and I want to keep every one of them as long as possible. And I don't understand this concept that landlords are trying to get rid of tenants or any of that, because that's not what any of the landlord friends that I have think or say. It's the cost of turnover is a lot more than any raise of rent. It's expensive. You have to fix the thing up and then find the right tenant again, and it's expensive. As far as this whole $1,000 thing, like Mark said, it's not worth it. What are you going to get? An extra $50 a month? It costs more than that. The only way that could be worthwhile is if someone has 1,000 units and they're trying to get a rental increase across the board. Small landlords, I would never, don't even bother, I would say, with that. That's not even, it has no value. The $1,000 fee for, I mean, it's the paperwork itself sounds like a big pain in the butt. I wouldn't bother. So as far as the rental increase, though, I mean, the state has implemented a cap on rent. It's enough. I mean, if you take the state's cap on the rent, it does not cover the increases that we're bearing right now with the water. For commercial buildings, water's doubled in the last couple of years. Garbage has doubled. I don't know about double, but it's gone up a lot. Insurance has doubled and people can't get insurance. New buyers can't get insurance. How am I supposed to sell my building if I want to? Nobody can make any money with it.
Thank you. Are there any more speakers in the room? I see a couple. Mallory?
Yeah. Hi, everybody. First of all, I want to request that people say where they're from. And if they're out of town, we should know that.
We can't require that. So you can
can't-
ask for
you-
that, but
you-
we cannot require that.
Okay. You're spending money on consultants, a lot of money on consultants. I think when Frank was here, they knew how to make decisions without so many expensive now consultants. And I would like people on the town council to either know how to do this without having so many consultants or get off the town council. Because we don't need to spend over $1 million on this, plus this extra 1,000 and whatever else we're paying. I took a video because when somebody was talking, and it was Mark, or hardly anybody was looking at him. And that's why I took a video, because I think you guys need to pay more attention and be more respectful of the people who are talking. Thank you. Also, this is not kindergarten, and I don't think you should be treating us as if we were in kindergarten, because we're not. We're respectful adults, and we want to be respected. And if you want to be respected, then you're going to have to do the same. And I also want to know how many corporations are landlords here versus how many people are on Social Security trying to get by and stay in Fairfax. Because we keep talking about it, and you guys make it sound like the corporate takeovers are going to be the problem. And I don't think that's the problem. I think you guys are the problem. Okay, and I would like to see that change. And the other thing is,
Thank you, Mallory.
I'm going to vote for you not to do
Thank you.
this.
Thank you.
You're not meeting.
Next speaker, please. Naomi?
Hi, I'm Naomi Schultz. I've lived in Fairfax for many years as a renter, and I still will probably be a renter for many years to come. And I want to thank you all for all the work that you've done so far on making these ordinances happen. And I want to remind you all that this has been a many-year process so far, and it's time to implement these ordinances to the degree that we can. A lot of things could change come November, for better or for worse on the local, regional, state, national level. And that's no reason to stop this process that was begun many years ago. So I think that the kind of information that everybody will get through the process of implementing these will make both landlords and renters be able to understand what's in front of us better and really have a sense that there is a process at work. So I urge you to implement. Thank you so much.
Thank you, Naomi. Any other speakers in the room? I see none. How many hands do we have on Zoom?
We have 10 raised hands on Zoom.
Okay, let's get started.
The first speaker is Laura, followed by Michael. Laura, you're unmuted.
Hear me?
Yes.
Hi, my name is Laura McMahon. I'm the Executive Director of Legal Aid of Marin. Legal Aid of Marin strongly supports the partial implementation brought before the council tonight, and we applaud the town manager, the town attorney, and the town planner for their efforts. Legal Aid of Marin's mission is to create an equitable Marin by empowering the community through legal representation, advocacy, and education. And we do this by representing and assisting thousands of low-income and otherwise marginalized residents of Marin each year. And this ordinance is in effect, plain and simple, and accordingly it must be implemented now. And to not do so violates the law. Rent stabilization is important because Marin lacks affordable housing. And we see so many people that come to our doors who are between a rock and a hard place. They're experiencing poverty. They're experiencing very difficult circumstances. And so many are at risk of becoming homeless. Some of them do become homeless, are experiencing housing instability, and really lives can unravel because of the consequences of systemic poverty. And so we are in full support of rent stabilization because at the end of the day, we believe that Marin can be an inclusive place where people can stay and they can live life to their full potential, and landlords can have a reasonable return on their investment. So thank you very much. Legal Aid of Marin is in support of the partial implementation.
Thank you, Laura. Next speaker, please.
The next speaker is Michael, followed by Deborah Benson. Michael, you are unmuted.
Hello, Council. Michael McIntosh. First thing I'd like to point out
is money going to Marin Legal Aid should be disclosed because they benefit from this process. They increase their budget, they have more to do, and they can acquire more money. But really what I see, and I'm just amazed that you're doing this, you had the people come and speak to you. They voted to put forth an initiative in good faith. This is what democracy is all about. And you ignore what they brought forth, and you just keep doing what you want to do, even knowing that when we vote in November and you lose this position, I think anybody who's incurred any expense has a legal claim. That's the law to go after you guys. But what I really see overall, and this is what surprises me, if you guys do your math, and if you look at the garbage and the water and the electricity and the insurance, I don't even think 7% across most rents would actually cover that. And your landlords or housing providers in Fairfax, I don't know anybody that raises the rent that much because as one gentleman spoke, you do your best to keep your tenants, especially your good tenants. So if a tenant, for instance, myself last month had a medical condition, I ate that month's rent. That's what you do for your good tenants. But more specifically, I see your continued actions are a slap in the face of the general public. I see that you're creating this division. No matter if you smirk or think it's funny, look what you're doing to the community. You haven't reached out to the community. Who are you protecting? Like I brought up earlier, Sheila McNeil, she's now at the Martinelli House just as a temporary with a raise of rent of $1,100 a month. Please represent the entire community. You are failing. Thank you.
Thank you. Next speaker, please.
Is that fair?
You should address the fact that.
Next speaker, please.
The next speaker is Deborah Benson, followed by Ben. Deborah, you're unmuted.
Thank you. Thank you, council members, for hearing me. I'm wondering why you're even talking about this evening before the outcome of the referendum and not having the respect that Larkspur had for their constituents. I'm curious about the timing and the chain of events that led to what's going on the table tonight. Council passed this ordinance without adequate forethought as to legal ramifications. Two council members recently attended a protest alongside tenants of the Lanai Apartments complex. The owner was raising the rents above the allowances of the ordinance. There was no avenue in place for the landlord to appeal the restrictions. Is this needing an after-the-fact resolution to some anticipated or pending litigation? We pay our town attorneys hundreds of thousands of dollars yearly. Is this a cleanup of cart before the horse? Something being done wrong here when we have to spend so much more in legal fees to defend our actions than we've ever spent before. Conclusion, you aren't going to listen to anything we have to say tonight. It's a given, and that's regrettable. So thank you for hearing me, so to speak.
Thank you, Deb. Next speaker, please.
The next speaker is Ben, followed by Jody. Ben, you're unmuted. I think you need to unmute there you go.
Okay, unmuted. Okay. So I have a few comments and I welcome any answers if so be it. So first question is, with the limited increase of say 2.52%, if say as a landlord, you opt to not increase the rent in a given year, do you get to bank that and, you know, could you increase it by double that the following year? Would be question one. Question two, the $1,000 fee for any kind of a protest. If you win that appeal, do you as a landlord not have to pay that if it turns out you were in the right to appeal that? And then again, I'll just go back to the cost of the implementation. To implement it before the election doesn't make any sense. Seems like, the fact that you're doing the election in November instead of March seems like kind of a cynical ploy to get more people to vote the way that you want them to vote. And just close with, to me, it just seems totally wrong that, who are you to decide what's a reasonable rate of return for a landlord? So that's all I have to say.
Thank you. Next speaker, please.
The next speaker is Jody, followed by PJ. Jody, you're unmuted.
Good evening, Council and Mayor. I believe that you know that many of us in Fairfax support rent stabilization. We also support you moving forward with the implementation tonight as outlined in the staff report. I feel like option A is very cautious and fair to both renters and to housing providers. And this implementation should get underway with these steps at the very least. So I encourage you to move forward tonight, and thank you very much for your time.
Thank you. Next speaker, please.
The next speaker is PJ, followed by Lynn. PJ, you're unmuted.
Thank you, PJ Pfeffer, speaking on my own behalf as a Fairfax homeowner. Just wanted to read out from the municipal code some of the service professions covered: people who do alterations, appliance repair, artists, auto painting, auto repair, barber shops, beauty shops, bookkeepers, catering, ceramics, dressmaking, janitors, laundry, music teachers, newspapers, tailors, tree trimmers, locksmiths. Professions that are also covered range from accountant, appraiser, architect, attorney, auctioneer, broker, chemist, auditor, dentist, draftsperson, geologist. Point being, all of these professions, if you want to operate a business in the town, you need to register, get a business license, pay a license fee, and there's other fees that apply to having a business permit. It's a bit ridiculous that someone in the business of providing rental housing to someone, where the stakes are much higher, the amount of control and power they have over the person paying for their services in their business, it's really extreme, aren't subject to the same registration and permitting and licensing requirements. People have raised the point about why are we spending the town's funds on this. I think it would be a very good investment for the town to set up a robust registration system so that they can actually collect appropriate fees from people running businesses in our town. They're free riding off of the town's resources, and that their business is getting the benefit of all the money that the rest of the town's residents are spending to maintain the roads and things like that. Setting this system up would be a very good investment that would ultimately give a financial benefit to the rest of the town that the town really deserves.
Thank you. Next speaker, please.
The next speaker is Lynn, followed by Chris. Lynn, you are unmuted.
Hi. I agree with like 90% of the people that have called in tonight, but I just would like to know if there could be full disclosure about which one of you thought up this idea or where you got the idea to do this. It feels like it's a power trip, and it's fishy towards the people that got together and signed to get it on the next ballot. So it's like a workaround, it's like we're going to get our way, it's wrong. And I don't know why you're spending a penny before we don't vote on presidents before the election day. Why are we doing this? It's crazy. It feels like a payback, and legal aid doesn't help homeowners, by the way. Homeowners aren't getting any financial support. So I just wanted to say, and this is something I wrote down, I really feel it about what's going on. It is certain, in any case, that ignorance along with power is the most ferocious enemy justice can have. And I think you guys are on a power trip about this, and that's not fair. And it's painful to be everybody talking. And I know it's going to be, you guys have already made up your minds, and this is just like a courtesy. I mean, I would be shocked if 4 of you decided not to do this. That would be a shock. So it's painful. And I'm sorry. It's upsetting. It really is. Like, why can't you wait? Why are we even, I want my road fixed in front of my house. Keep asking for that. Don't tell me to send another email in to get it done. It doesn't happen. It's just wait. It's just insanity. Yeah, that's it. I'm fed up. Goodbye.
Thank you. Thank you, Lynn. Next speaker, please.
Hi.
Please stop. Next speaker, please.
The next speaker is Chris, followed by Kay. Chris, you're unmuted.
Hey, town council, sorry about that. I'm calling tonight to support an immediate implementation of rent control. The people who started organizing for rent control in Fairfax almost 2 years ago expected implementation long ago. I think it's time to, get it done with the help of in-house staff and not outside contractors. I'm hearing a lot of landlords here tonight that are arguing against implementation because they are worried about being able to afford to keep the properties. And I think I would just like to call that concern out as generally being kind of nonsense and self-serving. If you pay attention to the money that is coming in to prevent the implementation of these ordinances in other jurisdictions, you'll realize just how money the anti-rent control movement is. And if they're genuinely actually concerned about their personal finances, I might recommend not spending thousands of dollars of their guaranteed profits on trying to repeal our representative democracy. I think it's totally fair to be worried about the rising price of utilities, but forcing that cost onto someone even more disempowered than you are is self-defeating. Many renters would support an effort against our utility monopolies that would benefit all citizens, landlords included, and that would be an actual movement worth getting involved in because it would change the power structure that affects us all. Thank you guys for your time tonight, and yeah, let's get it done.
Thank you. And please be quiet. If you want to speak, go outside the room. Thank you.
I'd just say that all of the responses from people after people are speaking, it's so embarrassing. It's really embarrassing that that's the state of democracy that we're in, that you will talk down, you will shout down people that have a different opinion than you. Be respectful, please. Even to people on Zoom, you're talking while we're trying to listen and take notes from your neighbors on Zoom. People were born in Fairfax, and you're still coming with that same energy. Please, just be respectful.
Okay, well, I would just say this, please be quiet. If you want to speak to one of your neighbors, please go outside. But we do want to be able to hear what people have to say. You may not agree with them. You may agree with them. Regardless, let's move through this. Who's the next speaker, please?
The next speaker is Kay, followed by Wendy. Kay, you're unmuted.
Hi. I don't even know what to say now after all that. Watching from Zoom, I can say it is pretty obnoxious how often you have to tell people to be quiet. I wish people would understand and get it. I just have I want to say, first of all, I am disappointed that these are the only options that staff came up with. I don't feel any of them are feasible, and I think it's absolutely ridiculous to even put in your packet of hiring someone on something we're going to vote for in 8 months. I also think the $1,000 is excessive. I personally think the landlord, the proof of burden should be on the landlord. They could submit a spreadsheet, whatever someone can look at it. If it equals the correct rate of return, it's a done deal. I'm curious if that $1,000, I think that could go into the rate of return, because that is an expense that the landlord is having from their profit. So that would automatically then go to the tenant to pay. And Lanai, if she had done it, would she have had to pay, I don't know how many apartments are there, but would she have had to pay $30K to do this for each apartment, or 40 or whatever? And then could she have put that into her costs and then get that back from tenants. I'm just curious about that. And that's all. Thanks. Bye.
Thank you. Next speaker, please.
The next speaker is Wendy, followed by Morgan. Wendy, you're unmuted.
Hi, I am calling in. I missed most of the beginning of the meeting, but I'm calling in to say that um, these laws have waited a long time to be implemented. It's not last moment before an election. And this process actually started many, many years ago, officially in 2019, but I actually had been begging for many, many years before that. And I'm really grateful that the town is finally paying attention to the inequities between homeowners and landlords and tenants. And I'm really saddened by the way that this whole issue has torn apart the town that I used to live in for 11 years and still love. Just needed to say that out loud. Thank you.
Thank you, Wendy. Next speaker, please. How many more speakers are there?
5.
Okay. Next speaker, please.
The next speaker is Morgan, followed by Kristen. Morgan, you're unmuted.
Hi, thanks for everybody being here tonight and trying to express what they feel in the most, honest way that they can. And I appreciate all the work that everybody's done on the council to try to implement these ordinances. I'm a Fairfax renter, and we've had many challenges with the state of our apartment. And I feel like there's this pressure that if we speak up about the leaking roof or the rats that chew in our attic, and the issues that we have with the property, leaky water main that cost $1,000 bill and things like that, I feel like my wife and I, who's on Social Security, it's stressful to feel like that if you speak up and say, hey, can you fix these things? Are you going to get told that you are going to be evicted? So these ordinances protect that kind of situation. And our rent, has gone up. We're paying $4,000 a year more than we were. And, so that's, these are real consequences. So I hope that the ordinances will be passed and folks like us can get some relief. So thanks to everyone for participating in this process.
Thank you, Morgan. Next speaker, please.
The next speaker is Kristen, followed by Mo. Kristen, you're unmuted.
Hi, this is Kristen. What I've heard tonight is a lot of fear from a variety of people being worried about being able to survive and maintain their homes, households, and livelihoods. And I think we need to take this seriously and have empathy. These concerns are not unique to Fairfax. Marin County just completed their 4-year needs assessment survey for older adults for 2023. Financial security is the concern that increased the most since 2019. Affording living expenses such as utilities, groceries, and healthcare is a big struggle. As the cost of living continues to rise, many older adults on fixed incomes can't keep up and struggle to make ends meet. 47% of those surveys say it's difficult to live on their total household income right now. Older adults with the highest levels of concern around affording their rent or mortgage has doubled since 2019. Housing affordability struggles are more pronounced among people aged 60 to 64. This group is also significantly more likely to struggle finding employment than the older cohorts. Without employment, it is hard to pay rent or mortgage. Many need or want to rent. Many need or want to provide housing. These ordinances are controversial, as you can hear tonight. I ask that you please consider the needs of renters and housing providers in an equitable manner without prioritizing the needs of one over the other. Whatever you decide, please track the efficacy and the financial, psychological, and housing impact on both renters and housing providers of all ages, and be open to adjusting and listening to all members of our community as we move forward. Thank you.
Thank you, Kristen. Next speaker, please.
The next speaker is Mo, followed by Allison. Mo, you're unmuted.
Good evening, everyone. This is Mo McManus. I am a longtime Fairfax renter. First off, I'd like to thank the council again for this endless amount of work. I'd also like to say that I respect everybody's opinion tonight and appreciate that. Bottom line, I'm going to keep this quick. I've been with you or been on this since the very beginning. It's been voted on, it's been agreed by the town council. I think it's time to implement. That's really all I have to say. That's it. Thanks.
Thank you, Mo.
The next speaker is Allison, followed by Kurt. Allison, you are unmuted. You need to unmute yourself.
Sorry about that. I'll make this quick as well. I'm a former Fairfax renter and I was affected by a high rent increase, which my perception was because we had asked for several repairs. Our landlord ended up renting the unit out at a lower price than she had raised our rent to, which further emphasizes that it was retaliatory. My main point that I want to make, as others have made, is that this rent stabilization ordinance was already passed. It should be implemented, plain and simple. That's all I have to say.
Thank you. Next speaker, please.
The next speaker is Kurt. Kurt, you are unmuted.
Good evening, Council. My name is Kurt Reese. I am co-chair of the Marin chapter of the Democratic Socialists of America and our rent control campaign, and a San Anselmo renter. I know many of the folks in Fairfax speaking against this item, and rent control won't mind that since they routinely show up in my town to speak at our town council meetings. I'd like to thank the council and the staff for really excellently prepared staff report and for taking up this item. I urge you all to move forward with a robust implementation plan. Tenants and landlords both deserve comprehensive implementation and enforcement, and whatever you can get done ASAP is, I think you all should get done while you figure out the longer term details. Yeah, and just piggybacking off the last speaker, I mean, I think that the whole framing of this discussion for many of those who have given public comment as being ridiculous because a ballot referendum is coming in November, I think is a completely absurd and inverse way of looking at this. Rent stabilization is the law. It was passed in November of 2022, more than a year and 3 months ago. It should have been implemented immediately after it went into effect. That's how laws work. This is frankly, way overdue. So, renters deserve real protections, and frankly, landlords deserve clarity about the process that they need to comply to. So please move forward with whatever you're able to implement as soon as possible. Thank you so much for your time.
Thank you. Next speaker.
There are no more speakers on Zoom.
Okay. So bringing it back, I just want to, I want to get a couple of points of clarification out and maybe some questions. Number one, Legal Aid of Marin agreed to do this work for the town, whatever work they are doing, which is some of the FAQs, working with our attorney, some of the tables that are on the website. That was for 18 months at no cost. So they're not getting money out of this. And when they represent low cost or low income renters, they don't get paid. So they exist on a pretty small budget. They get grants from the county and others, but nobody's making a lot of money at Legal Aid of Marin. And number two, I think when Lanai Apartments wanted to raise the rent, and I actually reached out to Miss Kanan Black and communicated with her. But at that time, I had talked to our attorney about if we had a process in place the thinking was that it would probably be one hearing because it looked like there would be one rent increase for everyone. And it would be based on this similar sort of situation. Now that may have changed, and I know she drew back from that, but that was the thought that was had. I think there was also a question about, we're not hiring staff to do this work. The housing specialist was contemplated to be hired to implement the many programs in the housing element. And we always knew that that staff person who will be starting soon would also be working on other elements of the planning program. So not 100% time on everything affiliated with the housing element. So this is our staff's estimate of probably a quarter time of that person to answer the phone. So one of the questions, I just want to say, when it was a ballot initiative, not a referendum, as some have said, and when there was a decision that came to the council about when to put it on the ballot, we had two choices. One is this past November election, which is what I had asked for and was outvoted by the rest of the council. Or we had the option of putting it on the November 2024 ballot. And I would like the town attorney to explain, there was no option of putting it on the March 5th, 2024 ballot. And could you explain, it's specific based on the timing, and please speak directly into the microphone because you tend to go quiet too.
Okay, is this good?
Yes.
Like this, okay. Yes, we had the choice of November 23 and November 24. And the reason is because you could have done a special, but it wouldn't have been in March. The special had to have been between 88 and 103 days from when it was presented to the council for action. And that March 5th wasn't in that time window. So it couldn't have been March 5th of this year. But you could have had a special. It would have been at some point in time between 88 and 103 days from when it came to the council for action. And I'm sorry, I don't have those dates right at the top of my head, but I can certainly look those up for you if you'd like. But March 5th was not, it was way outside the window.
Okay, so just to clarify that, and
then can we just,
yes, go ahead.
and then the town would have had to pay for that special election. Absolutely.
Well, and I think that's understandable, but the option was not there. So had we done it in November 2023, we would have had to have paid, and that was my push. I wanted to move it forward as quickly as possible so we could get certainty. The rest of the council members didn't agree. And I also want to say one other thing. Somebody said there were two things. One, that this is a special meeting. This meeting was well advertised. We specifically had this special meeting because we knew we had two items that were going to take a lot of time. And we wanted to make sure that we spent the right amount of time and gave it attention. The March 6th agenda is already packed with items. And so this was advertised, it's on the website, everybody should sign up for agendas, we post them. And so this is not transparent, which somebody stated. So there's that. Somebody else stated something about rubber stamping. And I want to say that I've made, and all of us have done this at times, I've made my positions, which have not been popular, clear. I vote with my colleagues when I believe that we've made the right choice. I vote against when I don't believe that that's the right choice. And I think everyone has done that on various occasions here. So nobody's rubber stamping up here. And I think what I just want to say is staff have tried to do something. When the Lanai apartments happened, the concern was everybody was going to have to lawyer up. That was going to cost a lot of money. So even though $1,000 sounds like a lot, it's actually a very cheap option compared to having to go to court, which could be drawn out and very expensive. And my feeling, just my own feeling was, let's provide landlords or housing providers an option, just in case somebody wants to go above that rent cap. And that's where staff came up with what I think is kind of threading the needle on, a partial. We know that that vote in November could overturn both ordinances. We know that, and that could happen. So why go into this full speed ahead, which some have urged us to do? I don't think that makes sense either. But this is really, let's get some staff in-house up to speed on this. We have a new staff person starting soon that'll be in place hopefully by April 5th. So somebody can actually answer the phone. Right now, the calls are going to our town manager. And we want to get somebody trained up to be able to answer these questions. One of my thoughts were if there could be a part of partial A, which is really just having the warm line and not actually proceeding with the hearing examiner approach and the paper registration. And if an event comes up where somebody wants to raise the rent above the annual general adjustment, we could bring this back. So that's something to be thrown out there. But I want to just ask, I've spoken a lot. I apologize for that. I jumped ahead, but I wanted to clarify some of what I think were some misconceptions that were out there. Asking my fellow council members, do you have questions for staff now that you've heard public comment? Or do you want to just go straight to deliberation?
Two questions
Go for it.
for staff. Thank you. And thanks for that recap. The first question is to Heather. I think I captured the number, the figure. There's so many numbers, and I hope we get to them in deliberations a bit. But there was a number about $209,000 housing specialist. I was wondering if you can speak to that, because then there were like fractions of that number that were thrown out, but that was a public comment that I'm hoping you could speak to.
I'll start and then I'll turn it over to Jeff. And we worked on this together. So that estimate includes a person and the support that they would need in terms of technology. So that was if you conceive of A, B, and C as being sort of low, medium, and high, that was the higher of the estimates. And I don't know if you want to add to that, Jeff.
No, I don't have anything to add. I mean, I think we assumed a one FTE or one staff person, and then the technology cost would be about 75,000 for kind of a relatively robust system.
And that was for beyond option A, correct?
Correct. That's option C.
Apologize for interrupting.
No, thank you. And that's exactly where I wanted to go, is just to confirm that that's actually not what we're talking about tonight. We're talking about a $5,000 option. But the other thing I had a question about was, I think, I don't know who brought it up, but the $30,000 for a 30-unit complex or something. There was a question about a hypothetical. Does like a larger multifamily housing complex, if they wanted to do petitions, do they do petitions for every unit? And does that all of a sudden mean that it's a 30-unit complex, $30,000, or are we talking about something that's more streamlined for that housing provider?
This contemplates just a very simple, if you want to have a petition with a hearing examiner, it would be just a flat $1,000. So it would be very flexible. It could be, if they wanted to raise the rent on half of the complex versus the full complex, then they could do that. Or if they, because they may have tenants starting at different time periods.
And would it be the same, would it be that $1,000 fee for no matter how many?
Correct.
Okay.
Right, so they have one unit, it's $1,000. They have 40 units, it's that.
Correct.
Okay, thank
That's
you.
the way it's set up.
Okay.
If I may just add, so the idea is the data that needs to be processed is basically the same, whether it's that group or that one.
Great.
Can I just chime in that some of the clarifications the mayor made and then some of your comments, I would really appreciate be reflected in the minutes just to clarify for the community some of these facts. Would that be okay? Thank you.
The other question I had, there was a question about the timing around implementation, and some folks might not remember that in addition to the law passing, as folks mentioned, November 2022, and a slew of meetings over the subsequent year, there was an implementation item in December 6th of 2023, where staff originally brought forward like a warm line option, and that was like $36,000 for a different community group or a different service provider. But the council gave different direction. I was wondering if you could speak to that, just because it sounded like some folks might not be aware.
I believe, didn't we pull that item?
We did.
I
So
don't-
you didn't discuss it, but the agenda was posted and the staff report was posted. And so, yeah, that was a nonprofit that offers that. Warm line service is an option different from in-house staff. And the estimate was $36,000.
Okay, so that's 7 times more roughly than what you brought forward today. So significant reduction in what's been provided today, $5,000 versus that estimate for essentially far more services. Would that be a fair statement?
They're not apples to apples, but in this case, the warm line would be provided by, a small portion of a staff person that has already been budgeted.
Great. Thank
Can
you.
I just clarify? So one of the things that was just talked about is if there's 40 units and housing provider X wants to raise the rent similarly with all those 40 units or 20 units, that we look at that could be one hearing. But if there was for some reason a differential where 5 were certain rate, 5 were a certain rate, 5 were a certain rate, and they were differential, then we would treat those as separate hearings. I don't want people walking away thinking that we could combine all those if it was differential. It might be that renter X started this date, and so there may be differences. So I think we would have to look at each on a case-by-case basis. But in the case of Lanai, it was our understanding it was looking at a certain percentage across the board, and that we would have treated as one, correct?
Yes, so I would say it's our intent to group as much as possible together so that we wouldn't have to, it's not our intent to try to, charge people. This is a pass-through cost. It does not benefit the town in one way or another. And as far as my understanding of the Lanai situation is somewhat limited, but if it was $100 for every unit, then I would assume that the information coming in would be about, overall costs for the entire complex. And that would then be divided by the number of units. And so that would make it very logical to be one hearing.
Okay, I just want to make sure that people don't walk away if for some reason there's a very differential process, then we'd have to look at those separately. Okay, other questions?
Yeah, this is a question for Jeff or Heather, because I've done a lot of looking at other programs up and down the state. And from what I've learned is that programs that are in full rollout, the fiscal impact tends to be net neutral, like the one just passed or the first reading passed in Concord. Is that your understanding that, well, I didn't see any mention, or I could have missed it, about a fee ultimately that would fund the program. So I'm talking about B and C, and I don't want to go down the rabbit hole with B and C because we're really talking about A, but I do feel like it's a little bit misleading or could be confusing to the community when we say town expenses, when it would be it would be structured in a way that would be net neutral, net zero in terms of expense to the town, fiscal impact to the town.
Jeff, your mic
Yes,
is on.
yeah, and the one, that's generally how it works is that there is a fee collected, which kind of has the budget for a program, and then the stabilization program operates within that budget. So that's why they're neutral. It's because the fee would total up to a budget, and then that's what. Yeah.
Thank you.
So in other words, theoretically, not taking away from streets and roads or whatever, it would be its own funded program.
Yes. Self-funded.
Correct. If you were going to go for full cost recovery, then it would,
and that's the
fees would
norm.
match the budget. Correct.
But that's full implementation, and right now we're not talking
Yes, but I'm talking about the columns, Barbara, that or Mayor, that refer to expenses, and they don't talk about how they would be offset.
Okay, in the staff report, but option A does not include developing.
But I was referring to B and C.
Okay, well.
And I said that, B and C.
Okay, well, let's just make sure that people understand that right now there is no fee, but if we moved forward into these other options or in even fuller option, we would look at that fee. More?
No more from me.
Okay, Councilmember Ackerman. We have the 10 o'clock rule. Can we, there isn't any other items, but.
Suspend the 10 o'clock rule or move
Okay,
past it.
someone second that? Ackerman, so Catrano, then Ackerman. Could we get a roll call vote on that?
Councilmember Ackerman.
Yes.
Councilmember Hellman.
Yes.
Councilmember Catrano.
Yes.
Vice Mayor Blash.
Yes.
Mayor Kohler.
Yes, thank you.
So I don't have any questions at this point. I'd just like to I'd like to make comments.
Okay, go ahead.
Okay, so if we're to that point. First of all, thanks to staff. I know you worked on this hard, and I appreciate the clarity of it. I'm thinking about option A. I'm not thinking about the other options tonight. And even in the column, as was pointed out earlier, in the column in this table for option A, there's stuff that we're not considering tonight. So there's a $10,000 in option A. That's not what we're considering tonight. So it's a very small program. And that's what I really appreciate about it. It surprises me how clean and simple it is. It, to a large extent, is aimed, I believe the design of this program is this early phase implementation is designed to address a problem which housing providers currently have, which is that this law is in effect, even though we haven't implemented it, meaning we haven't set up any infrastructure around it, but the law is still in effect. And as the owner of Lanai Apartments found, they can't actually raise the rent higher than what the law says. And yet the whole point of this was that housing providers would have a way to appeal that and a way to come and argue their case that they needed to raise the rent more than that amount in order to get a reasonable rate of return. They don't have any of that because it's not implemented. So this is addressing that. It's helping them out. So I think I think it's a good thing that you created this for us to consider, and I thank you for that. One thing I've really noticed, other than just the anger in tonight's comments, was a number of wildly wrong figures as to the cost of it. I heard $600,000 several times. I heard hundreds of thousands of dollars another time. None of those figures are within an order of magnitude of what it would actually cost. It's very, very inexpensive, mostly would pay for itself. Part of that is a misunderstanding about the housing specialist, but as Mayor Kohler got clarified, and as I think we all on the council are well aware, the housing specialist has been budgeted all year and hasn't been hired yet, but might soon be. The housing specialist is being hired for a lot more reasons besides these ordinances. The housing specialist is being hired because we're in the process of getting our housing element certified, hopefully very soon to be certified, but we've done a lot of work on that and we've done a lot of zoning, but there's still a lot more to do. And there's programs in the housing element that need to be implemented. And so a housing specialist is contemplated for that reason. This is only a part of what the housing specialist would work on. And it's actually supporting renters is actually also part of the programs. So that's part of the reason for that, but maybe another part of the reason for those wildly inaccurate figures is just anger and the fact that people don't read the staff reports. It seems like it's just, I mean, it's pretty clear. It was a very clear staff report. Thank you for that too. But, you know, if people don't get their information from actually reading the primary sources and get their information instead from hearing something from somebody else who heard something from somebody else who heard something from somebody who's so angry they can't even think, then, well, I guess the information is not going to be accurate. And that really brings me to what I think that the advantage is of trying to do this now rather than waiting until after November to do anything. And that is that you can't have democracy if people don't know what they're voting on and don't have the facts and are wildly wrong about what the facts actually are that they're voting on. And that's what I see us heading toward, and it really worries me. And I've seen this happen in Fairfax before in some other areas as well, and it really upsets me when people are arguing their cases and even taking something to a vote without really having a clear idea of what it is that they're voting on. So I think if we were to try to do something like this, a very inexpensive, very modest implementation that starts to allow some discussions to happen, like a discussion between the lanai owner and their tenants, could have happened through this process. And that would have been a better process than what did happen. That's the right thing to do. And let us all see, let the citizens of the town see, let the housing providers and the tenants in the town see how this works, to actually start having conversations and try to work things out with each other within the framework of these ordinances, but within the flexibility of having an actual human that they can talk with. And that actual human would be a staff person, which, as has been pointed out, has the advantage that we learn, that staff person will learn. And even if another staff person takes over that job, there'll be some in-house learning that goes on as to have possibly modifications to the ordinance. We've already modified these ordinances fairly substantially, and we can continue to modify the ordinances. So as we learn from experience as to how this works, to actually start to have these discussions that we envision and resolve these issues, kind of like the Planning Commission does. When you have arguments between neighbors, sometimes the Planning Commission has to help sort it out. This is something that happens, and we're trying to set up a way to do this, rather than just pushing. So, I think that. And there's another reason to start now, which is that people need it. There's actual suffering out there, and people need it. So I think that's what I wanted to say about why I think this is option A in its simplest form is a reasonable approach.
Thank you. Vice Mayor Blash, did you have something?
Yeah, I just want to say a little bit. First off, one thing, I appreciate people coming to talk. It's really great that people are passionate. I know, as a person who used to sit in that audience and make comments, that when there's a large audience that wants something that you want something different, it can be very chilling when you stand up and people are hissing and mumbling and throwing their chairs around while you stand up and try to speak. And I think we all care strongly about democracy and free speech. And some of free speech is letting people express an opinion that's different than yours. And I sit here and very patiently listen to opinions that are different from mine. And I want us to extend that courtesy to all our neighbors and not make it so scary that, people tell me they're afraid to come in here and speak now because of the way the rest of the audience comports itself. So I just want people to keep that in mind, that it can be really scary. I think that's why a lot of people are calling in now. We want democracy in Fairfax. Okay. I also just want to, kind of note that it sort of feels like the voices of tenants get erased. People say we're the people, but we're all the people. The tenants are people too. They do speak out here at hearings, and they're speaking out much more than I think they ever did before we had these ordinances. So I just want us to be aware that not everyone's a landlord, not everyone's a tenant, and we can hear those voices of people who are saying things different than ourselves without mumbling and throwing things around and, causing a ruckus. I did want to note, or maybe check with our town clerk, I received at least 8 letters of support. And there were a number that came in sort of late in the day, so I'm not sure they were in the packet yet. Is that, I'm not sure if you have them online or.
They're not online, but they were printed and included in the hard packet out front. Okay. There were about 4.
Like if they come to just the council members, are they still getting?
If they come to just the council members, they don't get included in the packet or posted online unless you share them with me.
Okay, so that's good to know because I did receive a fairly sizable number of pro as well as against emails, and I do read them all. Okay. The other thing I just wanted to note is that, I received a letter and also heard some comments that kind of compared what I'd call a minor bureaucratic inconvenience with basically the Holocaust. And I do not think that's appropriate. I'm really concerned that people are doing that in the current situation that we have going on in the world. So, please, keep your comments. You can be very angry about the implementation, but this is certainly not the Holocaust. People have to register to vote. People have to register to drive cars. People have to get business licenses. None of this is a precursor to some sort of fascist state. Okay, so those said, I just really want to note that I am 100%, for a form of rent control. This means a lot to me. But I am, kind of, concerned about moving towards implementing this when it seems like the people who it's intended to help don't want it. And then, it would help tenants as well. And, just the fact that we are going to vote on it very soon and we're going to be setting up this system that will probably go away, even if it's really cheap. So, and I know some people are going to be very disappointed that I'm saying that, but I am just a little concerned about that because, it could go away in fall. If it didn't go away in fall, I would, I just see nothing wrong in investing in our renter community. That's why we have, a town council. That's why we have a town, is to try to take care of the people of the town. And that might mean, so I don't have a problem with that. And I feel sometimes like the comments that come out make it sound like we don't value the tenants in our community. They're not really people. They don't really pay taxes. They're not really the people of Fairfax. And I don't like that. So I don't think there's anything wrong with investing in our people. And also, as Kristen said, investing in our homeowner and landlord population as well. There are different programs where we can do that. It doesn't preclude doing that also. Okay. I also would like us to, also think about how we are going to continue to invest in education on legal rights and fair housing. Maybe training for landlords to understand their rights and responsibilities if they're very small and they haven't had a lot of background. Shallow rent subsidies is something we may talk about at some point for helping low-income tenants, home match programs. So this is not, the be-all and end-all of what we could do. I also want us to keep in mind that, in the future, if we implemented more robustly, we might want to partner with another jurisdiction that if other jurisdictions do indeed pass this kind of legislation. And I also just want to really encourage those that advocate for this to put a lot of energy into educating your neighbors and other people in the community about why you're so passionate about this, as I think the landlord group has done, to, get your point out there. It can't all be the town council. We can't advocate on behalf of this. So it's your job, if you want to do that, to do exactly as the anti-group has done. I understand that some of them are better resourced and whatnot, but I do encourage people to, get out there and make your, whatever your political position is, make it known and educate people about the facts. Don't give people disinformation, and, engage in the democratic process. And part of the reason that I voted to put this on the November ballot was because that will be when the largest number of people are voting. And, we have seen in recent struggles in the US that we actually want to maximize the number of people voting on an issue, because that's when we get maximum democracy. So that's it.
Thanks. I'll go next. So I'm a little torn here. I had reached out to Ms. Keenan Black, the owner of Lanai Apartments, and suggested to her that there could be a hearing examiner process that could be put in place that would allow her to go to the hearing examiner to try to justify the need for a higher rent increase than the annual general adjustment. And she said, oh, I didn't know that that was available. She also told me that she had a medical event and she had pulled back. And I said, well, it's not in process, but it's something we've talked about. So I'm torn because I heard from her, who was the one person who tried to put together a rent increase without checking in with the town. And I think just based on that interaction, I think she would have been interested in pursuing that. But I also heard tonight a lot of folks saying, we don't want it. November is a long time away. So I go back to one of the ideas that I had, which I'm sure won't be popular here, is let's get the warm line up and running so people can get their questions answered. It's not going to be a legal interpretation. It's going to be, to the extent feasible, have a place to answer your questions. If you're a landlord or you're a renter, we'll do the best we can. And our town attorney, as well as our planning director, Jeff, will be trying to get that person up to speed. And if the November vote does not overturn the ordinances, then we could be on our way. And so I'm really torn, but I'm kind of thinking, because there isn't a pressing need right now for the hearing examiner, that I would push for, let's do the warm line. And if there is a pressing need for the hearing examiner, we bring that back. So that's kind of where I'm at. I had an idea for the ordinance about keeping the $1,000. It's on the last page of the ordinance where it says landlords shall, right at the top, landlord shall pay this fee until such time as the rental housing fee is set. And I kind of thought maybe we should get rid of that, because we can always, the idea is, if there's only a few housing providers that want to do this hearing examiner process, is it fair to figure, oh, we're going to have 20 of these hearings and then include that in the fee that everybody gets charged? Maybe it is, because it gets diluted among more people. I'm not going to bring that up tonight, because my feeling is I'm kind of more with, we really don't know what's going to happen in November. I don't think there's a pressing need for the hearing examiner today. I would like us to get our new housing specialist, along with the many duties that he or she will be doing for the housing element, up to speed on the warm line. But I'm not sure that I want to go ahead. I mean, I don't want to go ahead with the hearing examiner at this point. I don't think it's critical. And I think, should it come up, we could bring it back, because it's fairly simple. So that's my thoughts. But I want to say, I really appreciate the creative thinking that went into this. It is a low cost way of getting things off the ground, but not so far into it that if we need to pull back after November, we haven't expended that much, but we have helped people in the interim. But if we don't need to pull back after November, then we've got a running start. So I think the warm line will be important because 8 months is a long time. People have questions. People ask questions tonight. So that's where I'm at. And with that, I would ask if someone would like to make a motion.
Could I just add a couple comments too?
Sure.
Thank you. Yeah, no, I appreciate all the dialogue that's happened thus far. I think one of the challenges that I have with, and I'm supportive of the warm line of people feeling like they can go to someone that, especially someone in town hall that, you know, is dedicated to getting them the answers to their questions. Heather, I think you've done a great job, but you're also doing all of the things, and we need you for the big picture thinking for the town as well, and managing all the other folks. So I would say the challenge for me with no hearing examiner and the no pressing need thing is that we didn't know that Lanai was a pressing need until a bunch of tenants started asking, what the calculation was and whether or not their increase was correct. And like, we didn't know that there would be lawyers then going back and forth with the tenants and the owners of the lanai, and then that resulting in a discovery that, since the ordinance passed and it was retroactive, there were years of, illegal increases that had to be repaid. I mean, like there was a lot that came up. I don't know how much that cost for all those lawyers to go through that stuff, but the idea that there's no pressing need, I don't want to presume for the homeowners and housing providers in Fairfax that there isn't a pressing need. I mean, someone brought up the cost of new roofs. I don't know about the rental I'm in, but across from me, I see another rental, and the roof definitely needs to be repaired at some point. But I imagine like a housing provider might take up this petition process and take advantage of that. And I think for all the people that wanted to see what this could look like in a small town like Fairfax, it would be really good to see. And please, I'm trying to speak. I respect, I'm taking notes from all your comments. You don't have to talk while I'm talking in the crowd. Thank you. But it would be good, I think, for folks to see for an extremely low cost and low investment, what the process could look like as we go into, I mean, it's great that we've been able to see what the laws have been able to do for some folks since they've been in effect. But I think to even get a partial implementation would be beneficial to the voters of Fairfax, just to know that the sky isn't falling when we start to talk about these sorts of things. The other thing I wanted to share too is, we'll have the warm line either way based on the proposal you were just talking about. The hearing examiner piece is basically if a housing provider or a tenant, but in my perfect case, there's a housing provider that wants to see what this is and take advantage of it. But there isn't a lot of skin in the game until somebody steps forward. So for us to pass the resolution amending the ordinance to create more flexibility in the event that somebody does come forward, and then we say, oh, great, we know that there's a housing or hearing examiner that we could bring on. We can go through this process. Maybe somebody just talks to the warm line and gets their answers, and they don't need to file a petition. That'd be a best case scenario. But like, I think there's no reason to not amend the ordinance to create the flexibility in the event that a housing provider comes forward and says, I'd rather do this than spend $20K or $40K on an attorney in municipal court or something.
Well, you know what? You just convinced me.
Oh, great.
Because I think, thinking about it more, we're not training up this hearing examiner. This person has done this He's not affiliated with the Berkeley Rent Board. He's not affiliated with Leah Simon Weisberg. He's not affiliated with the Democratic Socialists of America or Marin. And so we're not investing anything. We don't have, if a housing provider doesn't want to go through the process, they don't have to. But if they want to, then it really is a low cost option. So I do appreciate your comments. And I think if we were investing a bunch of resources into getting this all up and running, I would still have my concerns, but you're right. It's just an option. And it is lower costs than getting attorneys and going back and forth and a lot of confusion. So
Barbara.
thank you. Yes.
Are you done, Chance? Okay. Yeah, I'm just going to piggyback on that. When the Lanai situation came up, I was really, really uncomfortable that we don't have a mechanism today to support landlords and should they want to increase the rent beyond the cap. And similarly, you know, if a tenant wanted to resist or push back on an illegal increase, we don't have anything to support them. They would have to go out of pocket and lawyer up. You know, yes, if they were low income, they could get potentially support from Legal Aid of Marin, but so it just doesn't feel responsible to me, a year plus not having tools in place for the community. And I've been working on this with Councilmember Cutrano and staff for several months on all these options, but primarily this creative solution, which is, you really provided a great staff report. Thank you again for that. I just think we need this mechanism in place for both parties, both the tenants and the
okay.
so I'm happy to make a motion.
Go
I
ahead.
just need a little more clarification. Okay, so sorry, but that's the process.
Yeah.
Yeah. So I also just wanted to clarify that, you know, had this come up like March of last year or something, 100%, let's just go for it. Because it would have provided us with the information that we need to know about how to implement, whether, you know, how it works. It would have given people a lot of information about how it works. And it just feels like this is a little bit too little too late in some ways, although some people are starting to convince me. But so I just wanted to put that out there. But I did want to get some clarification from staff about costs, right? So, I mean, you know, frankly, the base cost for this is like as much as it's going to cost us to put banners up for the merchants downtown for a month. Like, so it's not a huge cost. It's tiny. And I think that there's, you know, some misunderstanding maybe in some parts of the audience that somehow landlords are going to be forced to do something here. And this seems to be largely voluntary. So again, about the costs. So if we have this and say nobody comes forward, how much does it cost?
Well, I think we would still have the cost of the warm line.
Yes. Okay.
For the internal staff cost, but you're correct. You wouldn't have it if you didn't have any petitions, and you wouldn't be
right
any cost for the petitions. Yeah.
Right. So then how much would it be for just the warm line and say we just had no petitions?
I think we were just assuming like a quarter of the housing specialist position. So just a labor cost of that position.
And I just want to tack on to that because the last time I asked Heather, she in the beginning after we passed the ordinances, a high volume of inquiries, right? But the last time I asked you, you said 2 to 3 a week.
Yeah, I would say it's gone down very considerably, and it's really seems to be it picks up around council meetings, not so much about specific questions
about their circumstances.
Exactly.
Yeah, and you're most often pointing them to our website with the information, FAQs and applicability grids and so forth.
Exactly.
Yeah. So this is not a heavy lift, Vice Mayor. And it would be in place for 7 months. So,
and yeah, I'm just going to also note that the last time I tried to look up attorneys, it was like $450 or $500 an hour. So if somebody needed to use an attorney, they would go well over that $1,000 really fast. If they were going to a private attorney, it just is enormously expensive. So it, would be in some ways probably a deal for somebody to be able to spend that little.
Okay, so Councilmember Hellman, you would like to make a motion?
Yes, I'd like to make a motion to adopt resolution to start partial implementation of the rent stabilization program, option A, and introduce the ordinance to amend chapter 5.55 rent nope,
No.
sorry.
Reading by title only.
Oh, sorry.
Wait first, yeah.
Do I just read all three of them?
So
Sorry.
the first part is we've already discussed.
Yes.
So you want to go to number 2, which is adopt a resolution, et cetera.
Okay, I move to adopt the resolution to start partial implementation of the rent stabilization program.
And then number 3, you would say read
by title only and introducing an ordinance amendment to chapter 5.55 rent stabilization program of the town code to provide for an interim $1,000 petition fee to cover the cost of providing a hearing conducted by a hearing examiner.
And would somebody like to second that motion?
Yeah, I'll second it.
Okay, so that was Councilmember Hellman, seconded by Councilmember Catrano. And Madam Clerk, could we have a roll call vote?
Yes, Mayor. Councilmember Ackerman,
Yes.
Councilmember Hellman,
Yes.
Councilmember Catrano,
Yes.
Vice Mayor Blash.
Yeah. I'm gonna wait.
No, you have to vote.
I have to vote. Okay. I guess because it's incredibly low cost and voluntary, yes.
Okay, and I'm going to go with yes as well.
Thank you.
Okay, so we'd like to adjourn in memory of Fred Lee Berensmeyer. Some of you may know that his wife, Jean Berensmeyer, we adjourned in her memory a few months ago, and Lee just passed away. Thank you.
Thank you.